And my lord,
What is the urgency?
my lord, quashing of FIR.
So what is the urgency? Quashing
My
of
lord,
FIR?
urgency. My lord, I am still confusing whether your lordship will take up the quashing of FIR or not. My lord,
No.
the urgency. My lord,
It can't be. I am not a criminal bench. Go
no,
to the
I have come under Article 226.
226 might be, but it is not a criminal bench. Residuary criminal is not coming under the residuary. Only the criminal matter, criminal revision up to 2015, not the new one.
My lord, I am coming, my lord, under Article 226.
Maybe, but the police can't. The criminal matter cannot be taken by this court.
My lord, this is also, my lord, relating to police. But
Police, you go to the police.
No, but my lord, the police, only police in action, my lord, that I am confusing.
What is your prayer?
My lord, my prayer for quashing of the
Quashing of the FIR. Correct.
Under Article 226.
Correct. Go to the other court, not this court.
But I'm paying leave to it's for filing notes of arguments. It was kept. Matters been made part heard. It was listed, my lord, today, and my lord, on the 6th court days, it's not come up, my lord. It may come up any day.
Yes. उसको देखो.
It was
उसको to be mentioned में रखो. Tuesday में रखो. Tuesday to be mentioned.
मतलब
Inform the other side.
because husband wife.
Inform the other.
मतलब these two matter was appearing underwriting urgent motion, upgraded motion before Honorable Justice Amrita Sinha. Because I prayed for emergency interim relief, my lord. But after determination change, my lord, it is not appearing. My lord, I only prayed.
What is urgency?
Urgency is this, my lord. We are giving the only on-board housekeeping service to the railways. We are the society, and my lord, our bill more than 3 crores has been deducted without giving any notice. Or that the salary of the employees, those who are working in respect of on-board housekeeping service, my lord, they are not getting last 2-3 months because of this money which was withheld by the authority.
So if it is an employee, how this court?
No, not an employee. This is the society.
Society.
Tender matter.
Readings completed.
Yes, I have served the notice also.
Hey, Wednesday कर दो. Adjourn motion.
Not Wednesday. This is on Friday.
Wednesday adjourn motion. Friday. Friday means 21.
Yes.
21. 21 adjourn motion.
My list is most also relating to pension.
No list. Only today I am taking. Otherwise, you come on Tuesday or Thursday, sir. Or mentioning. I am not taking mentioning any other day. Okay, you come on Monday. Mention the Monday. I will sit.
I'm praying leave to move on urgent matters, my lord. Petitioner before lordship is student of class 10, my lord. My lord, what has happened? There is a mistake in the my lord Aadhaar card. That's why, my lord, for registration process, my lord, petitioner my lord, is in trouble, my lord. My lord, petitioner has applied through online mode for the my lord, Aadhaar authority, my lord. Even after representation made, my lord, the correction has not been made, my lord. Now, my lord, from January also, my lord, the NEET examination will be
correction in Aadhaar card.
Aadhaar card. Only name will be corrected in.
So how the court will interfere in that?
My lord, the Aadhaar authority is not acting in terms of the my lord. Their
Aadhaar card nowadays it is open.
Yes, my lord, I have applied in online mode. In 4/8/2025, my lord. Thereafter, I made representations.
To whom?
Then, my lord, as of date, my
it
lord,
is online.
Online, I have applied for, my lord.
Through whom you applied for?
My lord, through online mode, my lord.
You are directly applied for?
Yes.
Not through any agency?
No. Directly through website, my lord, I have applied for. I have annexed all these documents. Thereafter, I went to the regional office at Salt Lake, my lord. My lord, they told, since you have applied through online mode, we don't have any authority to do anything else. I made representations before the authority since it is pending for more than 3 months, my lord. And my lord, examination will be approaching very soon, my lord.
When the examination is there?
Test examination, my lord, form will be filled up, my lord, this month.
Whether any notification is issued regarding the filling up the issuance of the form?
No, notification as of date not yet issued, my lord.
You file it and mention. If it is there, then you mention. I will.
My lord, kindly fix next week any date, my lord.
So file it.
My lord, I'm filing it.
You file, then come.
My lord, with your lordship's kind permission, I'm seeking leave with your lordship to move an urgent matter. The petitioner of your lordship is a registered refugee under the United Nations. Now, what has happened is that the petitioner has admitted his wife in the Alipurduar hospital. On 6th of November, the wife had expired. Now, the issue had arose that the hospital authorities are not releasing the body because they want the Aadhaar card. Now, your lordship, under section 10 of the Registration of Birth and Death Act, the Aadhaar card is not a mandatory document.
Not releasing body?
Yes, your lordship. They're not releasing the body, and now they are stating
Where is the body now?
In Alipurduar hospital, your lordship. Alipurduar.
Yes. Why it is not been released?
They are just asking for Aadhaar card. But since
Aadhaar card of?
Aadhaar card of the petitioner and his wife. Now,
Who is the dead person?
that person is the wife of the petitioner, Your Lordship. The petitioner is the husband of the deceased.
Husband of the deceased.
Yes, Your Lordship. So under urgent, Your Lordship will kindly grant me a leave to move this matter because
How she died?
she died because of cardiac arrest, Your Lordship.
So there's
On-
no criminal case, nothing.
No criminal case,
So
nothing.
how it was taken to hospital and declared death, or during the
On fifth,
treatment?
the wife was admitted to the hospital.
Hmm.
On 6th, she expired, Your Lordship. And the hospital authorities, they are just demanding the Aadhaar card. Otherwise, they won't issue the death certificate or they will not release the dead body. And now they are stating after a span of 14 days, they will cremate
When
the
she died?
on in Alipurduar Hospital on 6th of November, Your Lordship. Thereafter, we made representation, we made follow-ups to try to get the body legal way, but they were not, willing to comply.
Have you filed the writ petition?
No, Your Lordship, I'm seeking leave before Your Lordship because
Granted to
grateful.
Leave granted to affirm and list on Monday.
I'm
You see, you send the notice to the other part.
Huh.
You should and file affidavit of service.
grateful, Your Lordship.
My lord, under extreme exigent situation, my lord, under extreme exigent situation, my lord, mentioning item number 165, my lord, of your lordship's list. My lord, the difficulty is, my lord, the petitioner is a company and the respondent is, my lord, Controller General of Patent Designs and Trademarks. But they have issued a notification of public notice against me, which has already been stayed by this coordinate bench of this honorable court. Now, my lord, despite of this stay, my lord, they are simply circulating, my lord, the impugned notice. And my lord, the head of the respondent authority himself is posting it regularly in the LinkedIn, my lord, commenting and inviting general people to make complaints against him.
Whether the interim order passed by this court is continuing or not?
It is continuing. It is continuing.
It's still in existence.
It is still in existence.
Ah.
Miller, we have filed the can, Miller. The difficulty is, Miller, due to this activity, Miller, on a regular basis, Miller, my reputation is, Miller, being hampered. My business, Miller, is at the verge of closure now. Miller, more than 700 employees, Miller, is serving in this company, Miller. If I am not protected at this time, Miller, it will be very difficult, Miller, to survive the business.
So now what
any time today, Miller, I want my can application to be heard today itself. Miller, any time, Miller. It is listed, Miller. It is listed 165.
एक काम करो 165 अर्जेंट मोशन में ट्यूसडे कर दो अर्जेंट मोशन में ट्यूसडे 165 come on Tuesday issue the notice to the other side informing the matter will be taken on Tuesday.
Already done, Miller. Already done.
Informing the matter will be taken on Tuesday as urgent motion.
Grateful.
My lordship, may I permit to mention one restoration application?
Come on Monday.
On
Come
Monday.
on Monday. Yes, call the list.
My lord, I am praying for
What correction?
Maybe there was some technical
ले लो Monday रखो correction में.
May I permit, my lord?
Monday correction for.
My lord, may I permit to mention, my lord, I am praying for inclusion in the list, my lord. There is a matter.
Come on Monday. Regular mentioning. Come on Monday.
My lord,
Yes.
this is urgent matter, my lord.
Correct,
The
it is
determination
urgent.
is changed. There is a issue. my lord.
Call the list. Call the list.
My lord, I appear for the petitioner, your lordship. My lord, this is appearing at my instance, my lord, for extension of interim order. If my lord is pleased to take a look at the last order, my lord, which is the interim order passed in the application in connection with the writ petition, my lord, dated 25th of September 2025. Now, the interim order is till the 15th.
Yes.
But just to give your lordship, my lord, in a nutshell, my lord, the background of the
Who is
matter.
my correspondent?
My lord, a senior friend is there, my lord.
Affidavit file. Affidavit's completed.
No.
No, my lord, in the application, affidavits have not been completed. In the writ petition, yes.
We have filed it yesterday, my lord.
Yes?
We have already filed it on yesterday, affidavit in opposition, and here is a copy.
Of can.
We have not yet received.
No,
my lord.
copy not received.
Served.
No.
No, not copy,
So-
not sir. I'm sorry.
Serve the copy.
Yes.
Give.
My lord, kindly gives us 3 weeks time to use the reply, my lord.
And what about the main writ application?
Main writ petition pleadings are complete.
Pleadings are complete.
Yes, my lord. Could I just indicate in a nutshell, my lord? In
Not necessary.
very well.
Are give the your affidavit.
Yes.
Union of India. How many respondents are there?
Two respondents, Your Lordship.
2. You are appearing for the only Union of India.
Yes, my lord.
What about the other?
Lordship, they have not appeared till date. my
They're not
lord.
appearing.
No, Your
No,
Lordship.
my lord.
Actually, my
But
lord.
this is West Bengal Electricity
Electricity
Regulatory
Regulatory.
Commission. They are not appearing, my lord.
The respondent number 1 has filed affidavit in opposition in connection with Can 1 of 2025. After serving the copy to the London Council for the petitioner, let the same be kept with the record. Counsel for the petitioner prays for time to file affidavit in reply. The petitioner also submitted the interim order granted by an order dated 25th September 2025 is still today. Still
It's
15th
really till tomorrow, my lord, 15th.
of November 2025 and prayed for extension of interim. But the London Council for the parties time to file affidavit in reply and the petitioners direct to file affidavit in reply within 2 weeks.
But could I get 3 weeks, my lord? It's a
Weeks.
public sector undertaking, my lord. So, my lord.
Within 3 weeks.
May I make a submission, humble submission? That is, learned DSG has also been appointed by the Ministry of Law in this matter, and he is also will be available from Monday. Kindly defer this this hearing till 12th or 13th, my lord.
Of December.
Not this month.
12th and 13th.
Fix it.
That is over.
After that,
When it is to be fixed?
the date of the relief, I mean, was fixed on 15th, 15th of November.
Yes, tomorrow.
15th of November.
Tomorrow. 15th November is tomorrow. Tomorrow is Saturday.
Oh,
Interim order was still 15th
yeah.
November and
If I am fixing after 3 weeks,
Yes, my lord.
fixing after 3 weeks,
After 3 weeks,
it's adjourn motion.
my lord, kindly make it at least 2 weeks, my lord, because that this non-compliance of the order of the Central Power of Ministry of Power is really very much injurious for the department.
Affidavit in opposition within 2 weeks.
Affidavit in reply, my lord.
Affidavit in reply within 2 weeks. List the matter on 2nd December 2025 under the heading adjourn motion.
The interim order, my lord.
Order is extended till 3rd of September, 2nd of December 2025 or until further order, whichever is earlier.
But your lordship is keeping the matter on, my lord.
2nd September, 2nd December.
My lord, may we
And
have
my lord, would your lordship kindly extend it for a day beyond that?
No, come on that day, come on that day. Adjourn motion, it will be taken up. If it's not, you mention it.
Fair.
Okay.
my lord, may we have the liberty to mention in the meantime
For what?
for vacating the interim order?
You file application, it will be taken. Have you filed the application for vacating?
Okay, my lord.
Have you filed an application?
No.
No, then.
Okay.
Grateful.
Yes, next.
Item number 2, my lord, I appear for the petitioner.
Lordship, may I seek
Yesterday-
a very short passover, Lordship? The additional solicitor general is before his legs before court number 1, Lordship. A very short passover, Lordship.
Paso. Yes, next.
But I am for the petitioner in this matter. This matter
was assigned by the Honorable Chief Justice to before Honorable Justice Amrita Sinha. Because my lord, earlier I have filed this application before court number 25, the then Honorable Mrs. Justice Rai Chattopadhyay. Matter was released, and my lord, thereafter matter was appearing before Honorable Justice Om Narayan Rai. His Lordship also released this matter. Thereafter, I approached before the Honorable Chief Justice to assign the matter in any other appropriate bench. The Honorable Chief Justice assigned the matter before Honorable Justice Amrita Sinha. Now, by the order dated 4/11/2025, Her Lordship also released this matter, and Her Lordship is of the view that the bench in which the Group 9 determination is there, that bench will take up this matter. So, I also, this order has been passed in presence of respondents, my lord.
Yes.
Problem is this, my lord. The fact of the case is, my lord, I am transporting the riverbed materials, sand, from one place to another.
Riverbed materials from one.
From one place to another.
Correct.
Now, on the basis of that, my lord, e-challan has been issued. That is page 15. Valid e-challan. When I was transporting the sand from one place to another through the national highway, sometimes the national highway, due to the tremendous traffic congestion, the truck or heavy vehicles are stuck up. Sometimes the red road parade is there. Entire highway will be blocked for no entry. It is the fault of the traffic department in respect of that. For that, my lord, they have mentioned certain time that you have to reach Kolkata by so and so time. My lord, if I running the vehicle in the road, nobody can assume the when the truck will reach. Now they mention the time. That time has expired. The BLO office has instant made a fine more than 30,000, 50,000, 1 lakh. Now, my lord, this issue has been considered.
What is the delay for reaching the vehicle?
My lord, that they did not assign any reason, my lord. Kindly see page number 17. Only they have stated, my lord, page 17, I am submitting, my lord. They have communicated this data. As per available office record, it is found that an overloading, they are saying overloading, sometimes they are saying time, case being number so and so has been lodged in WBMDTCL, app number such and such, against the vehicle number such and such. Therefore, you are requested to please come to the office of the undersigned for further information. This is the communication, only communication they have made. But I made a representation, page 14.
Then what has happened? You're not appeared before the authority.
But I made a representation, page 14. Page 14.
Page 14.
Yes. I am Bhajan Datta, proposal of Shivadurga Silka Sand Processing Works Unit, Panchmura, Bankura. I would like to bring to your kind attention that my truck bearing registered number so and so has been blocked without any prior show cause notice. I respectfully request that the above mentioned truck be unblocked to enable me to continue transportation of essential materials for my unit operation. Your kind operation in this matter will be sincerely appreciated. They did not reply in respect of that representation. Now, my lord, the bunch of matter has been appeared before Honorable Justice Om Narayan Rai. In respect of such matter, my lord, his lordship has passed to an order. My lord, I am giving the order. দিচ্ছি কর্মনা নেই, তোমরা সব বিয়ে করেছিল একসাথে। একই মামলা। Well, this is the order Because there are two category of order has been passed by his lordship. One in respect of impugned order passed, and one in respect of not impugned order passed regarding the blocked of each challan. So I think it is a balanced order, Mala. Nobody will be prejudiced because the district magistrate has directed to make a detailed hearing in respect of the grievance of the petitioner. And court has directed to pass the order in accordance with the act and laws.
না
Yeah, কি order, Mr. Sivan ভাবছি।
হ্যাঁ
No.
ঠিক আছে এই অর্ডার পাস হোক অসুবিধা নেই।
হ্যাঁ ওইটাই বল। Justify it. What do you prejudice? District magistrate को order pass करते हो।
Yes.
I want this order.
Yes, I will not stand in the way of passing this order. My lordship can dispose it of in line of the same order. Only difference in that case, well, the challan was blocked on different region, and in this case, the challan was blocked on for overloading matter.
Where is the challan?
Challan is my lord. Page number 15. Subdivision Bishnupur to Kolkata. This challan normally issued by the competent authority appointed by the government of West Bengal, my lord, at the time of loading the sand.
This is no, this is not the challan.
Yes, e-challan, my lord.
E-challan, yes.
E-challan. There is a portal, my lord. If they blocked, I will not generate the challan.
When it was blocked?
Well, it was blocked, my lord. Kindly see, I have made
15/5,
yes.
2025, 10/23.
Yes.
And the validity was 16/5 at 10/20.
Yes, they have mentioned the time.
10:23 am. When the challan was made?
The challan was made on the challan was blocked on 15/5 and it was made on
How the 15? How on 15? Acha, overloading.
Overloading.
So you have started from which time?
I have
Challan-
to within time.
Challan is valid up till 16th May 2025 from 15
In the road, they
24
have-
hours. 24
In
hours.
the road,
Huh.
just seeing the sand, they are saying
When
overload.
where is your pleading?
Yes. My lordship, can you see? Paragraph 4. The state of they valid the e-road each on sand.
15/5 on 10 p.m. When the Malat,
Where is that?
Malat, in my report, Malat, fact of the case, Malat, very first line, Malat, can you see?
In 5 a rate program had been going on.
At 12:02 a.m. on 16/5, it was, the vehicle was seized. On a midnight.
What is the permitted quantity? You are carrying 700 cubic meter. What?
Well,
is the
that
permitted
there is a provision. They have to pick up my vehicle and to go to the wet center.
Correct.
But they did not do so.
200 cubic feet.
They
more
did
than
not
the
show so.
permitted quantum. We have
But
stated
they are
also.
just seeing from
200
the ice,
cubic feet more than the permitted quantum.
just seeing the ice, and they are showing that you are overloading this case. There is a provision that you have to check the weight or check the actual cubic foot of sand. In the midnight, nobody is there. Only one officer has.
That is correct, Mr. Das. But
Yes.
once you have been given permission, what is the permission given to you carry the load in your vehicle for
Yes.
transport the sand?
Yes.
What is the quantity allowed to you?
But they
So
did
they,
not.
they,
They
the
did not.
police, the respondents have taken the plea. It was stopped and they measured the vehicle as per the body measure. It was found that
Whatever they
700
have
cubic.
taken a plea, but there is a reasonable opportunity has to be given to the petitioner.
Correct.
That is why the Honorable Justice Rai has passed this order that just you have imposed a fine and you have blocked the e-challan. Where is the reasonableness, my lord, in respect of that? There is a procedure, my lord.
No, that is procedure. But once
That procedure they have not adopted, my lord.
once the e-challan has been given, now where is your vehicle?
My vehicle has been released, but I could not transport it. I could not transporting the sand because of the blocking of my e-challan.
Okay.
That is my.
The petitioner has filed the present writ application, praying for quashing or setting aside the imping office of letter dated 23rd June 2025, issued by the Block Land and Land Reform Officer Gohad Des Roman to HON'BLE on the allegation of overloading, carrying the sand above the permitted quantity in the vehicle of the petitioner, being vehicle number WP67C 2292 and e-challan has been blocked by the authority. The petitioner has made a representation to the authorities, but the authorities have not considered the same till date. The petitioner submits that before the blocking of the e-challan, no opportunity of hearing was given to the petitioner, due to which the petitioner is facing difficulties. The petitioner has relied upon the judgment, the order passed by the coordinate bench of this court in the case of Abul Qasim Ali Shah versus State of West Bengal in WPA number 11177 of 2025, dated 12th September 2025, and submits that in the similar circumstances, the coordinate bench of this court has passed an order directing the authority to give an opportunity of hearing to the petitioner and give an opportunity of petitioner and to pass a reason order. Full stop. Counsel for the petition submitted. If the similar order is passed, comma, the petitioner will be satisfied. Then at counsel appearing for the state. You are appearing for the state.
I'm led by Mr. Amol Sen, madam.
State has submitted the report and submit that on 15/5/2025, a raid program had been going on at about 10 p.m. onwards near Bengai Mode within the jurisdiction of the said block under the said block, and during the checking at about 12:02 a.m. on 16/5/2025, the vehicle of the petitioner was stopped by the checking team, and on checking it was found that the vehicle has been carrying a huge quantity of the sand. On the basis of a challan by numbers, on the basis of a challan which was allowed the vehicle to carry only the quantum of 700 cubic feet of the sand, and accordingly the appropriate action has been taken by the authority. This court find that the grievance of the petitioner that e-challan has been blocked due to which the petitioner is facing difficulties. This court also found that in the similar circumstances, the coordinate bench has passed an order directing the authority to consider the case by giving an opportunity of hearing. In the present case also, it is the specific case of the petitioner that no hearing was given to the petitioner before the blocking of the e-challan. Accordingly, the present date application is disposed of by directing the following. सेमीकोलन 1 ए तक कर देना, यहाँ से लेकर के यहाँ तक. WPA number so and so is disposed of as no affidavit has been filed. The allegation made in the present application deemed to have been denied. I'm good. The paper like that, no? The report filed by the state be kept with the report.
But within a period of
What is the period given in that? 2 weeks.
Yes.
Within a period of 2 weeks.
15 working days. In that means 15 working days.
2 weeks within a period of 15 working days.
get
Deeply appraised.
Yes, next.
This is application for restoration.
Yes.
And my lord, the order was passed on 29 July 2025, dismissed this matter for default.
Where is our application? Can 1?
Can 1.
Where is the order?
Order, my lord, I have annexed this order.
No order is annexed.
My lord.
Where is the order? By which the writ petition is dismissed. Where is the order?
The order has not been annexed by I have stated in the
huh?
I have stated in the paragraph.
But you are not annexed.
No, I'm
good. By which order the writ was dismissed?
Paragraph P can see.
29 July.
Right.
Yes, what is the reason why you are not appeared?
Paragraph 3, paragraph 2 and paragraph 3, I have stated, the matter was taken up at 4:15. Now, when I was engaged in some other court, and my junior also didn't come.
Record or not. The petition has filed the present application being Can 1 of 2025, praying for recalling of the order dated 29th of July 2025, wherein this court, due to non-appearance of the petition at the time of call, had dismissed the writ petition for default. Counsel for the petitioner submitted the matter was running in the list, but due to some illness, the advocate on record has left the court, and the learned senior advocate who is arguing the matter was engaged before the another court, due to which the arguing counsel also could not appear before this court, and no representation was made, this court has dismissed the application. Had the learned counsel for dismissed the application for default. Had the learned counsel for the petitioner perused the application, this court finds that the petitioner has shown sufficient reason for non-appearance of the petitioner when the matter is called on 29th of July 2025. Accordingly, order dated 29 July 2025 is recalled. WPA 10643 of 2025 is restored in its original file. Full stop. Yes, what is the case about?
My lord,
10 is disposed
the
of.
matter the petitioner adopted one.
Okay, you should notice after restoration, the petitioner is directed to serve notice upon the respondent.
I went to serve this notice, my clerk, but
after restoration, indicating the next date of hearing, and to file affidavit service by the returnable date, let the matter appear on 26th of November 2025 under the heading new motion. Yes. Call the passive matter.
I appear for the petitioner, my lord. But,
yes.
Yesterday, my lord, I have submitted that the petitioner wants a liberty, my lord, to approach the learned court below. That is additional district judge at Kolani. Recently, the case has been committed to that court. For my lord,
which court the matter is pending?
It has been committed to additional district judge Kolani on 11th November 2025.
Additional district judge?
Kolani at present.
Okay. Additional district judge or session judge?
No, additional district. Sessions judge is my lord Nodia. Nodia is the district.
Criminal case.
It's a criminal case.
So how the district judge will do this?
Additional sessions judge. I'm sorry. I stand rectified.
Additional sessions judge?
Kolani.
Kalyani. Yes.
My lord,
what is the case against you?
The case against you is false promise to marry. It is FIR under section 69 351 2/77 3 and 5 of the BNS. Yes, my lord. False promise to marry. That's the.
In that case, the passport was seized.
No, passport was not seized.
For renewal.
No, passport was not seized.
What is your application for?
My application is for, my lord, that, my lord, I will go abroad. And my lord, I will go abroad. I need time till 2030. So I will go before the learned court below to pray that to grant a specific order for leave to depart from India, and the court must specify the time. That is the rules of the passport department. Yesterday, my lord, I have placed. I will place it again once more, my lord. And my lord, upon hearing me, if the court is satisfied, the court will pass necessary orders. Once the court passes necessary orders, my lord, I will approach the passport authority. My lord, they will take steps in accordance with law within a time frame. My lord, this is my.
So why you are not directly approaching the learned?
My lord, that will take some time. My lord, urgency is, my lord, 30th of November. My lord, I have to leave. Already I have got my chance for postdoctoral research.
Degree? What degree?
It's postdoctoral research, my lord. It is at page. It's at page 80.
80?
18. Current appointment for postdoctoral research associate in the School of Physics and Astronomy.
Appointment as postdoctoral research associates. Yes.
This year, my lord, I have got this one.
Termination will be 2027. So it is set to expire on 21st July 2025. Has been extended and your new term.
Extended, my lord, extended.
Correct. Till 31st of July 2020.
2027.
Correct.
I am praying for 2030 because again it will be extended for 2 years. I know that. That's why, my lord, my prayer before this court, as well as it would be before the. Well, kindly see.
But in the same page 30, the fourth point, no further extension or renewal will be granted on this appointment beyond the new termination dated 31st of July 2027.
No, my lord, if I go and join there, then, my lord, it's okay. If I don't go and join there, then, my lord, it will not be extended. And I have to go and join there. I have to leave by 30th of November.
Yes. At present, what you are doing in the same.
My lord, at present, my lord, what has happened? Why I prayed for anticipatory bail. There was a condition that I should not leave the district. Subsequently, the condition has been waived. My lord, kindly come to the anticipatory bail order once. Well, that is at page 28. 32, my lord, 32. 31 is, it starts, but relevant is 32.
Release on bail furnishing 5,000 with 2 securities. Yes.
And now, my lord, next page, I have annexed, my lord, page 33. Relevant page is 34. My lord, anticipatory bail conditions are waived.
Yes.
Commitment has been done recently to additional district court, additional sessions judge Kollani. And, my lord, my lord, as per the order, as per the rules, my lord, your lordship may kindly see at page 37. Yesterday I have placed.
Yes.
My lord, your lordship has seen 2, my lord, A. I'm reading 1. The passport to be issued to every such citizen shall be issued for a period specified in the order of the court referred to above, if the court specifies a period for which the passport is to be renewed for. So court must specify the period. If no period either or for the issue of passport or for travel abroad is specified on such order, the passport shall be issued for a period of 1 year. So 1 year, my lord, I will automatically have. Now, number 3, if such order gives permission to travel abroad, my lord, this permission is required. Travel abroad for a period less than 1 year, but does not specify the period of the validity of the passport shall be issued for 1 year. If such order gives permission to travel abroad for a passport for a period exceeding 1 year, well, this is what I require, and does not specify the validity of the passport, then the passport shall be issued for a period to travel abroad specified in the order. This is the specific case, my lord. I will make an application in accordance with this, my lord, GSR 570E, and the court will consider it accordingly, in accordance with law, within a time frame, my lord, that I pray for. And once the court considers, additional sessions judge Kollani, my lord, I will approach the passport authority. Passport authority will consider it within a time frame, my lord. This I want. And, my lord, in this regard,
Still you are in appointment is there, but you are not joined the duty there.
No, I cannot, because initially, my lord,
Which country?
Well, USA. Well, higher studies, USA.
If see the page 18, that your current appointment as so and so in the School of Physics and Astronomy is set to be expired on 31st of July. So when the case was initiated against you, when the FIR was initiated against you?
No, I was already, my lord, pursuing my course there. Now I came back to India because of this case.
My lord, I am from the state, my lord. The police has already given us a report. If your lordship wants, I may hand up the
State,
Yes.
This application has multiple clause of action. Renewal, permission to go abroad, and the other things which are mentioned. whether this is at all maintainable. Firstly, there is no question of renewal because it is the consistent view I had the privilege to argue before the learned single judge and the division bench of the Chief Justice that in case of a renewal, all formalities which are required de novo that are to be fulfilled. There is no question of extension at all. Number one. Admittedly, there is a criminal case pending. Now, if a criminal case is pending, there is a clear bar under section 6(2)(f) of the Act. For the benefit of the citizens, Government of India decided under section 22 of the Act to issue a notification. That is the GSR he is mentioning. Now, this GSR clearly provides two things. One, there must be at the heading permission to go abroad. That's the first criteria, permission to go abroad, and the period which is to be specified.
Yes.
Specified. Thirdly, that he has
Permission.
asked for the main issue which I had the privilege to argue before Lordship the other day, that it is also connected with visa. And the immigration department automatically comes in. Now, once a passport is granted, that ipso facto shall not permit the petitioner to go to USA unless visa is obtained. And if a criminal case is pending, that requires clearance from the state government and the immigration bureau. Otherwise, its entire thing will be a nullity. There were two things are to be adjudicated. Now, kindly come to the cases which are made out. Kindly come, my lord, to 21st July 2025 order at page 33.
Page 32.
33.
Yes.
This is the order, earlier order passed by the learned session judge Nodia. Kindly come to the bottom three paragraphs of page 33. Has you also got it?
Yes, yes.
Yes. Learned public prosecutor vehemently opposes the said prayer, stating that in the event of allowing such prayer during the pendency of the investigation will suffer, and not only that, after the investigation is concluded, the entire trial will be vitiated if the accused petitioner does not turn up before the concerned trial court. Having heard both sides, as aforesaid, and perusing the documents placed before the court, it cannot be denied that there has been a prospect of the accused petitioner so far as the betterment and upliftment of his future career, and thus such bail condition should be modified as he has already surrendered before the learned jurisdictional court and obtained bail. Therefore, keeping in view of the aforesaid submission and the development of the entire scenario, I think that there is a fit case for the said bail condition should be modified. Now, kindly come to the next page. Thus, in relaxing the earlier order dated such and such in connection with criminal case number such and such, that he cannot leave the jurisdiction of this court without the prior permission of the court, stands waived by directing him to furnish a local surety of such and such, and there should be a separate undertaking to be submitted by the accused petitioner himself, that he will make himself available before the concerned learned committing court at the time of commitment, and supply the copy, that he will also appear there before the sessions court after the commitment order is passed, and thereafter he will remain present on the date of framing of charge, examination, and such and such. A separate undertaking should be also filed. Therefore, this order, which is passed by the criminal court, is not in consonance with the GSR which has been issued under section 22.
Now, my Mr. Chakravarti, he is not asking any relief from this court, only directing and with the direction, let he file a petition before the learned trial judge, and trial judge will dispose of its own merit. He will consider your prosecutor take whatever the objection
Yes.
before the court. This court is not going to pass any order for directing the authority.
Yes.
He has only prayed for that a direction.
He wants to make an
If
application
he,
under
if
the
he,
under
if he
the
file an
GSR.
application before the trial court, the trial court may dispose because there is time limit, so that the trial court can dispose of the application within the time period.
Yes.
That is up to the magistrate.
But his prayer was also that his passport should be renewed for a further period of 10 years. And that is contrary to the order by the criminal court.
That trial court will decide. That trial court will decide why this court will take the jurisdiction of that court. Because he is not asking any order from this court for extension of time allow the petitioner. He is only praying since yesterday is praying that only he want an order, because he prayed filed this application only with the apprehension that he will go to the trial court. It will get delayed. If there is some direction will be issued by this court, the trial court will take cognizance of this order and petitioner will be heard expeditiously. So whatever
application will be heard expeditiously.
And after that, I will approach them.
You are not filed. If you petition filed,
Yes.
that will
I was suggesting, even if the trial court passes an order exactly in terms of the GSR, his problem shall not be solved because of the Immigration Bureau pendency of a criminal case. It is, I have done so many cases in USA visa. USA visa will never be granted if criminal case is pending. His problem will not be solved.
Also, but it is up to him. Let the trial court decide why this court can take the burden on that. I am disposing of only that.
Yes, grant him liberty to make an application which shall be decided in accordance with.
And if any application is filed, that will be decided in accordance with law within a period of 2 weeks, whatever.
And after that, my lord, I will approach them. They will also decide in accordance with. Then I have to approach them also, the passport authority.
That is with if any order is passed, then you can go to the concerned authority. So I am disposing of, Mr. Chakot.
Yes.
The writ petition, and the petition has filed the present date application.
30 তারিখের মধ্যে যাওয়ার ব্যাপার আছে।
With the prayer to grant a liberty to the petitioner to approach the concerned trial court wherein the criminal case is pending against the petitioner, to pray for no objection to go to abroad, and also specifying the date up to 2030 for which the passport is to be renewed with the permission to the department from India, and upon filing of such application, the concerned criminal court shall dispose of the said application within a specific counsel for the petitioner submitted that a criminal case has been initiated against the petitioner by the police of PS Kalyani, being case number 362 of 2025, dated 17th April 2025, under section 69/351 within bracket 2/77 355(3) and 351 within bracket 2/77/3 within bracket 5 of the BNS 2023. Full stop. After initiation of the case against the petitioner, the petitioner has applied for anticipatory bail. Initially, by an order dated 26 June 2025, the Learned Court has, the Learned Sessions Judge Nadia has granted anticipatory bail to the petitioner, and subsequent by an order dated 21st of July 2025, the condition imposed upon the petitioner was waived. Full stop. Now the petitioner submits that on 24th, the petitioner has received a letter from Head School of Physics and Astronomy, USA, USA for appointment as postdoctoral research associates in the School of Physics and Astronomy till the 31st of July 2027. The petition submits that due to the criminal case initiated by the petitioner, the petitioner is not in a position to proceed to abroad to pursue his higher study, but to join his post as per the appointment letter dated 24th of February 2025. Accordingly, an order is required from the trial court for permission to go to abroad. Full stop. The counsel for the petitioner has brought the attention of this court to the office memorandum dated 10th of October 2019, wherein it is mentioned wherein the passport to be issued to every such citizens on the following criteria. Semicolon does this ये set out कर दो हाँ 37 A का I ठीक है counsel for the petitioner submitted that the petitioner intend to file an application before the trial court, and if an application is filed by the petitioner, a trial court may be directed to dispose of the application within the specific period. The Leonard ESG appeared on behalf of the Union of India and submits that even if the permission is granted to proceed to abroad by the trial court, the petitioner has to obtain a visa from the authority, from the immigration department. And if the petitioner is having
and also the concerned embassy
and immigration as well as the concerned embassy, and if a criminal case has been initiated against the petitioner, he submits that there is no chance to grant any visa to the petitioner to proceed to abroad. This court is not going into the dispute whether the petitioner will get the visa or not. Here, in the present application, the petitioner only prayed for a direction upon him. Prayed for a direction in the petitioner will file an application before the Learned Trial Court. The Learned Trial Court can dispose of the said application within the specific period of time. Accordingly, the petition is disposed of by directing the Learned Session Judge.
Additional Sessions Judge.
Kindly do not say that why directly. Kindly grant him leave to make an application.
By disposed of with the petition disposed of by granting leave to the petitioner to approach before the Learned Trial Court for grant of permission to proceed to abroad for appointment for joining his service in terms of the appointment letter dated 24th of February 2025. If any application is filed by the petitioner, the Learned Trial Judge shall dispose of the said application after hearing the Learned Public Prosecutor, after giving an opportunity of hearing to the Learned Public Prosecutor or additional Learned Public Prosecutor or any of what is the public prosecutor, assistant public prosecutor? Who are there? In the
Public assistant
public prosecutor or any public prosecutor or assistant public prosecutor, whatever may be.
Kindly record in accordance with law in terms of the notification
within a period of 2 weeks from the date of filing of the application. It is made clear that at the time of hearing of the application, the Learned Trial Judge shall take into notice of the office memorandum dated 10th of October 2029.
10th of October 2020?
2019.
2019. That is in continuation of the earlier 570.
2019. Full stop. That's all.
Well, one thing, I will not join office. I will go for higher studies.
But appointment is mentioned. Kindly see your letter. That's why I'm asking again. It is not higher. It is not the higher study. It is appointment.
No, that apart, your lordship is aware.
Appointment after PhD.
Kindly see the letter.
Your lordship is aware that under the provisions of section 438, subsection 2 of the Criminal Procedure Code, once an anticipatory bail is granted, court is to record that the accused shall not leave the court without the permission of the court.
That's why now the court is granting earlier what the 438 anticipatory bail is granted subject to the condition 438 sub clause 2.
Yes, clause 2. Yes.
Clause 2.
And that order has also been passed in this case.
Correct. Yes.
Well, the affidavit of service be kept with them.
Affidavit of service filed by the petitioner become greater. So WPS instructions are disposed. Take the book. Yes, next. Serial.
My lord, may I please your lordship? Affidavit of service. My lord, the petitioner, my lord, in this writ application, my lord, he intends to challenge, my lord, a notice issued by the, my lord, respondent number 3 under section 94 BNSS, whereby, my lord, the respondent number 4 has illegally, my lord, not having the statutory competence, my lord, has directed to debit freeze my bank account. This is, my lord, one part of the challenge, and second part of the challenge is, my lord, for directing the bank concerned, my lord, to defreeze my account, my lord, on the reasons, my lord, which I will, my lord.
No, who has issued the notice?
Well, it has been issued by, if your lordship kindly comes to page 19.
Police of
Itanagar Police Station, Pampura, Arunachal Pradesh. Now, my lord, lordship will finally, first, my lord, before reading the notice, my lord, lordship will see.
So how the writ petition maintainable here?
My lord, my bank account is in Maniktola, Kolkata.
Okay.
I am from Kolkata. My
Okay.
bank account Kolkata, and I'll show you a lordship. Subsequently, my lord, the GST commissioner has also written to me. My lord, lordship knows, my lord, the power for defreezing or for freezing the bank account, my lord, rests with the GST commissioner, not with the police station. Now, my lord, if your lordship, my lord, kindly peruses this letter, lordship will find, my lord, some, my lord, party has committed some fraud.
Siddhi Vinayak Trade Merchant.
Yes, my lord, they have committed some fraud. I am not on that, my lord. Now, my lord, the remaining part, for the purpose of investigation, you are hereby directed through this notice to provide the following within 7 days from the receipt of the summons. CAF of following account number. First, my lord, the second one is mine. 502000125200175. This is my bank account number. Others, I am not concerned, my lord. Bank statement.
Investigation of the case revealed that the
Now, my lord, item number 3. You are further directed to debit freeze the above mentioned account. My lord, this is beyond his, my lord, competence, my lord. My lord, section 94 doesn't give him this right, my lord. If your lordship kindly takes up section 94 of the BNSS. Only, my lord, gives him the right to call for documents or to summon documents. My lord, this is the section. Yeah, my lord.
Yeah.
এটা জজ সাহেবকে দেবে।
$94.
$94, my lord. This is the notice under section 94. I ask this question to myself, how can he do it, my lord? Because under section 83 of the GST Act 2017, the power vests with the GST commissioner. He can do it.
Issue a summon for such matter.
He can call, my lord, for production of any documents, electronic, non-electronic, whatever document. That power he has. That power has been given to him in this section.
Yes, then.
Now, my lord, the reason, my lord, if your lordship kindly comes to page 25. Why, my lord, I was, my lord, involved.
You are further directed to debit freeze the above said wrong. Kindly note that the failure to comply with.
But this letter has been written to the HDFC Bank, local branch, not to me. I was not directed. Now, my lord, if your lordship kindly comes to page 25. This is the notice written by the respondent number 2, Office of the Commissioner, GST, to me.
Page 25.
Page 25, man. Mala, the commissioner doesn't debit freeze my account. Has your lordship got it, Mala? Page 25.
Yes.
Mala, I'm reading, Mala, the note, the contents. In an ongoing investigation of Messrs. Siddhi Vinayak Trade Merchants undertaken by this office, it has been noticed that the said firm has passed input tax credit to your firm amounting to rupees such and such. So this is the amount involved. 1,83,934.80. They are saying, Mana, their allegation is that they find that an input tax credit has been given to my GST account by this Siddhi Vinayak.
Who are you?
My lord, I am, my lord, a person, my lord, who carries business, my lord, of ferrous and non-ferrous metals from Kolkata.
What is the firm name? AS Enterprises.
My lord, AS Enterprise. My lord, never in my life, my lord, ever I had any business with
Just
this.
a minute. In an ongoing investigation, Ms. Siddhi Vinayak Merchant Traders undertaken by this office has noticed that the said firm has passed in ITC or to your firm 1 lakh. To your firm amounting to 1 crore 83 lakh. As regard your request, submit the following document within 5 days. Yeah, then. So
now, my lord,
how the Siddhi Vinayak has given the
my lord, may I, my lord? Well, if someone, my lord, passes any input tax credit to my GST, that is beyond my control. Now, my lord, the authorities rightly called me saying that you produce the invoice.
Correct.
Because according to them, there has been some transaction. They are right, my lord.
Correct.
Now, my lord, if your lordship kindly takes my reply, page 28, I had replied.
Appear before 2 p.m.
In this regard, at the outset, we'd like to have, we have not entered to any purchase transaction with the above mentioned. Malad, there has been no transaction at all. I have given my bank account details and Lordship, my lord, with this letter, I have annexed, my lord, if your Lordship kindly comes to running page 30, this is the enclosure.
This 1 crore 83 lakh 9.
This is 1 lakh 83. 1 lakh 83.
1 lakh 83. In
Yes.
which account it has come?
GST account.
Correct.
Not to my bank, my lord, to the GST. That is an input tax credit. Subsequently, my lord, I show your lordship, I have reversed it also. It was unknowingly there, my lord. Someone gives it to my GST account. It is beyond my control. Because I never had any transaction at all.
Preparing for the authority.
Lordship,
Now,
I
my
am
lord,
for
one
state
more thing,
respondent.
my lord, I have not
I am
completed.
for state respondent, Lordship. I think Lordship, Itanagar police station is answering respondent and bank.
You serve the notice.
Yes, my lord.
Or who is the for the commissioner, income tax, assistant commissioner, GST?
My lord, I have served everyone, my lord. Even, my lord, I have sent notice. Now, my lord, if your lordship kindly comes to page 31.
But other side is not there. How it can be heard? The court has to, the opportunities to be given to the other side. Bank as well as the GST as well as the Itanagar police station. Where is your affidavit service?
My lord, that's there. Again, my lord, bank, I have served by notice by mail yesterday also, my lord. Lordship directed me.
Where is the service? You are sent only. Where is the track report? Where is the track report?
My lord, then track.
This is the only.
Well, I'll give then on next date, my lord. Everyone has received. I'll give
I
the
started arguing the matter. Come without the affidavit of service, complete of 10 minutes, you are lost. The petitioner has filed affidavit of service, but it is found that there is no track report to show that the notice has been served upon the respondents. Accordingly, petition is directed to serve the notice upon the respondents and to file affidavit service on the returnable date. Let the matter appear on 4th of December.
My lord, Lordship kindly, my lord, keeps it, my lord, prior to that, my lord, as an urgent motion. Lordship
So
will because, my lord, I tell you, Lordship, my lordship will bear me for a moment. Now, my lord, there's a judgment of Rajasthan High Court. In case, my lord, if there is a tinge of fraud, 1 lakh, that
judgment
can be
will consider subsequently. Sir, first you have to complete the service. Itanagar you can serve.
Lordship will keep it next Friday. I'll serve, my lord. As an urgent motion, Lordship will kindly appreciate my predicament. I'll serve, my lord. I'll bring the track report.
Keep 25th of November kar do.
As an urgent motion, my lord.
Please mind it. I am fixing. If it is not served,
no, my lord, I shall come up with the track report.
Then you have to face the consequences of cost. I am fixing on as per your submission. If the notice is not served on 25th, then you put You have to put the cost.
But then Lordship will keep it on 28. Malad, because I taking it on myself because Malad, I can understand if the track report doesn't come.
That's what I'm telling.
28, Monday, Malad. Monday, Malad, as an urgent motion.
Urgent motion. Yes.
I'm grateful. 28.
Yes, next.
7 and 8. Blood 8 was it?
No report. Report filed. Straight.
Blood earlier report filed.
Take that. Hey, Babu.
Blood the earlier blood one report filed affidavit. But the subsequent by an order dated 12th September 2025, the another report blood because 33 lakhs I have seen 33 lakhs have been paid. However, blood another report has to be filed. But what happened
I
is
don't find no report is necessary because facts are admitted.
the court has directed. That's why, madam, submitted.
Malad,
Court has directed by the order.
I'm
dated
not
12th
quarreling
September.
with someone.
No, I'm not quarreling.
What
Well,
else?
what is well, it is now now become an habit.
Let the court decide.
Become a habit.
Who's happy?
But I am placing the order of the court.
Mr.
Is not necessary.
Mr.
It is above the court.
Please. Let the court decide whether the
Yes.
report is required
My
or
lord.
not. But as for on the 12th of September, as per the submission, the report be prepared and circulated by 25th of September, released on 7th of November. So as per the report, you have submitted the report or
Report. Blood, that's why I am submitting. Yesterday, there is an untoward incident blood, that Dipanjan Dottom that is no more in the panel. That's why blood, I had contacted him. The report is with him. Your lordship kindly takes up the matter. Blood, next week I will come with the report.
serve the copy? When you serve the copy?
25th order was passed.
12th of September. 12th of September.
12th of September.
Yes.
So by tomorrow you can serve the copy?
By Monday. Tomorrow is the holiday.
By Monday. By Monday, no problem.
By Monday.
You serve by Monday.
Monday.
And if exception you take, and I am fixing on 27.
My lord.
Malad, kindly keep it on Tuesday.
Okay.
I think no exception would be necessary. If then we will ask.
Mr. Swapan Banerjee, learned AGP, appearing for the state, please for a day's accommodation for filing report. Accordingly, the state is directed to serve the advance copy of the report to the learned counsel appearing for the petitioner by 24th of November 2025. List the matter on 25th of November under the same heading.
25th. I'm deeply obliged, your lordship, for accommodation. 8 and 11.
Yes, next.
8.
7, 8 both. Both are similar?
Yes.
7 और 8 করে দেবেন ওইখানে 7 লিখেছি।
I'm for the petitioner. May I request, Malad, if I can come back on Monday?
Why?
I'm for the respondent. I'm not ready in the matter, Malad. I've just been briefed. And Monday,
Not today?
Monday.
Next.
Well, item number 10, well, I require 2 weeks time to take instruction from the passport authorities.
Which for the petitioner? You are appearing?
Yes.
Item number 10.
Yes.
The SG is asking time.
To take instruction.
To take instruction.
Well, this is a case of a Rohingya, my lord. The petitioners are husband and
Okay,
wife.
let come with the instruction.
But Rohingya is getting passport.
No, my lord, I'm not paying
This is
for
something
passport.
unheard of.
But I'm not asking for passport, my lord. If my lord will kindly see, they were arrested on 9th February 2016.
Yes, these are.
Achha, that conviction is completed.
Back 8.
Where is now still in the correctional home?
Yes, my lord.
Why not deported?
8 years, 7
If
months.
the conviction is completed, why not?
No, I'll have to take instruction.
Okay,
At least give it some time.
But I will place on record a judgment of the
Okay,
order of
let the report come. You give me the judgment.
My lord kindly fixes a short date, my lord. 8 years, 7 months in custody illegally incarceration,
How
my lord.
soon? Within 10 days?
Custody illegally. By conviction order, not appealed against, but illegally.
My lord,
Conviction
conviction
completed. As per their conviction completed.
Very well, but illegally, how can it be said? Illegally, yes, there is that.
My lord, the Bhim Singh's judgment says that it's illegal. You cannot keep a person in jail indefinitely without any charges against them, without any trial. That is illegal, my
Yes,
lord.
John. Let
Incarceration right now.
Let the matter appear on 26th November.
26
My lord, it may be kept on top, my lord.
As urgent motion, Gori.
It is item number 10.
Grateful, my lord.
Lord, I am appealing for respondent number 7, 8, and 9.
11.
7, 8.
Item 11.
Yes.
Need to open. No, no, but
My
I
lord,
am
I am for the respondent number 4, 5, and 6.
I
The
have
bank.
taken the instruction from the.
My lord, I am appearing for respondent number 4, 5, and 6. My lord.
Your any objection for withdrawal of the writ petition?
No, my lord, I cannot. My lord, I cannot.
You are, madam, you are having any objection for withdrawal?
No, no, my lord.
Counsel for the petitioner has handed over a communication dated 14th November 2025 and submits that the petitioner has informed the advocate that the petitioner is not intending to proceed in detail. In view of the communication dated 14/11/2025, the counsel for the petitioner prays for withdrawal of the writ application. Consider the submission made by the counsel for the petitioner, peruse the communication dated 14/11/2025, WPA number 11366 of 2025 is dismissed as withdrawn. Communication be kept with the record. Interim order, if any, stand vacated.
My lord, appearances may be given. My lord,
Instruction be kept with the record.
My lord, appearances may be given. My lord, I am for the bank. My lord.
Please, Lordship, I seek a short passover in this matter.
Why?
I'm led by Miss Shandukta Mudumdar. He's engaged in court number 21, actually.
Passover, not today. Not today.
Gratefully, Your Honor.
Not today. Next. None appears on behalf of either of the parties. No accommodation is sought for. Accordingly, WPA 20616 of 2025 is dismissed for default.
Lordship, item number 14, I am for the.
Yes.
I am for the Zilla Parishad.
Who is for the
Petitioner is not
petitioner? Give.
I am for the respondent number 429.
Which one?
Item number 14.
Yes. Why you are not releasing the amount?
Lordship, I am just.
Have you instruction?
No, Lordship, I don't have any instruction.
He has completed the work. You issued the work order. The work has no. Why you are not releasing the amount?
Lordship, I am first time appearing, Lordship.
So what do you want?
Lordship, I
None
don't have
appears
any
on behalf of
instruction.
the
My previous
petitioner.
term. Sorry, my lord, I am for the petitioner
Which matter?
in item number 14, my lord. Mr. Author Banerjee is appearing for the petition, my lord. He is just coming. Yeah. Possible. Difficulties. It's a tender matter, my lord.
I am appearing for the Jilla Parishad.
Yes, have you instruction?
No, my lord, no instruction has been yet received, my lord.
First time I am appearing.
She is praying for the release of the amount, the work she has executed.
My lord, she is asking for amount, my lord, but there is some dispute. Let the matter be sent to the respondent authority for consideration. That is respondent number 3. Who is the appropriate authority?
So what? completion certificate is
Where is the
there, my
tender?
lord.
Where is the work order?
Yes, my lord. My lord, the work orders is page number P2 in annexed P2, page 22.
Page 24.
22, my lord.
22.
Yes, my lord. And my lord, in P4, annexed P4, page number
Just a
25.
minute. Just a minute. 24. Let the work order. Construction of CC road of irrigation band.
No problem. Respond number কত কত হয়ে আছে?
Yes. Then what has happened?
My lord, work completion certificate is there, my lord.
Where is the completion?
My lord.
Where is the completion certificate? Let the complete. Let's see. Let's see.
My lord, it is the annexed P4, page number 25, my lord. There is the work completion certificate, my lord.
This is a completion certificate. I don't know what is written here.
24.
Representation.
Yes.
And
The bill raised at page 24.
Yes.
Thereafter, Lord, I have made the representation before the authority for releasing of bill. Ultimately, my lord, next page, page 26. Lord, if your lordship kindly sees,
yes,
that this is the final representation that the bill I have raised that may be released.
Yes.
And it is to be released by the Jila Parishad, that is additional district magistrate, who is the competent authority. That is at cost title.
When the work was
number 3.
When the work was completed.
Yes, my lord. The work was completed, my lord, within the time, because acceptance comes, the work order was issued in the year 2023, that is at page 22. And my lord, we have raised the invoice, my lord, that is 2425. Invoice number 2425, Halda Jila Parishad. My lord, we have already raised, that is at page 24. My lord, if your lordship sees left hand column.
So there is no completion certificate?
No, my lord, we have submitted the, now the issue remains, in this case, my lord, work completion certificate then only can be issued when the bill will be released. That is the main issue. For such reason, I have, my lord,
yes,
indicated the same.
My lord, very outset I said, my lord, all oral instruction I am submitting to your lordship that work has been done. It is true. But in the tender, the particular place for which the tender has been issued, that portion work has not been done. In another place, they have.
You pass an order.
Yes.
Let them consider, my lord. I have
that is in
not
number 3.
Yes.
Respond number 3.
Yes,
The
yes.
grievance of the petitioner in the present writ application that the additional district magistrate Malda had issued a work order on 22nd of May 2025 for construction of CC road from irrigation band to Emmanuel's house at Uttar Rajapur, Dakshin, Khalsadar, Khashadar, Khashadara, Maharajapur, page 24, under Ratupur Development Block, Malda. Counsel for the petition submitted on receipt of the work order from the petitioner has completed the work and has submitted the bill on 21st of October 2024 for a total amount of rupees 4,13,574. After submission of the bill, the authorities have not released the amount. Subsequently, several representations have been made, but till date, no payment has been released. Then a counsel for the petition submitted that direction may be issued upon the authorities for release of the amount as per the bill raised by the petitioner dated 21st of October 2020. An advocate appearing for the state submits that.
Pardon, my lord.
Jila Parishad, my lord, is the competent authority.
Jila Parishad submits that the petitioner has made a representation, submitted the bill and made a representation. Let the authority be decide the representation submitted by the petitioner in view of the submission made by the concerned parties. The who is the authority? Who is the authority? Secretary.
Response number 3. Because he is the authority, but under the Jila
Malda
Bengal
and Executive
Panchayat
Officer
Act.
Malda Jila Parishad, Malda is directed to consider the bill submitted by the petitioner dated 21st of October 2024 and the representation submitted by the petitioner dated 11/11/2024 and 11/11/2024 and subsequent representation within a period of 4 weeks. Within a period of 4 weeks from the date of the order. And if the authority found that the petitioner is entitled to get the payment as per the bill raised by the petitioner, the authorities have released the payment within a period of 2 weeks thereafter. And in case the respondent authorities find that the petitioner is not entitled to get the payment, the respondent authorities shall pass a reasoned and speaking order. Reasoned and speaking. As this court has not gone into the merit of the matter, all the points are kept open upon the authorities to decide. WP is disposed of.
4 weeks, 2 weeks.
Yes, yes.
All points kept.
But I was in court number 1, Milord, I was addressing.
No problem.
Item number 15, Milord, as I appear and view the petitioner.
My lord, may it pleases your lordship, if it pleases your lordship, may I kindly be allowed to pray?
Yes.
For an, my lord, in this matter, I am appearing for state, my lord. My lord, in this matter, may I kindly be allowed to pray for an accommodation for a week, my lord? My lord, the instructions is awaiting, my lord.
May I submit, Milord, the representation to be considered, that is at page 20. Nobody will be, there will be no harm. Page 20, Milord, I have completed the work. They have accepted, and I have raised the bill. I have requested to consider the same.
But the bill is of 2021.
No, Milord, I have been released thereafter, subsequently, and ultimately.
When the amount was released?
Milord, some of the amount were released, Milord, in the year 2022. That I have indicated. For such reason, Milord, the final bill comes to 28 lakhs. That is at page 20. 28,84,190.
My lord, if I come back with an instruction just after 2 days, my lord, my lord.
Okay.
All right.
Learned counsel for the state. You are
my lord, state. My lord, state.
Counsel for the state. Prays for 2 days time to take instruction. According case is adjourned. Let the matter appear on.
Idea, my lord.
20 November. 20 November.
My has been pleased to fix the matters 21st.
2020.
20th. I'm grateful.
Much obliged with your kind
for the state, my lord.
But affidavit of service already I have filed, may be kept in the record. Earlier be kept.
Item number 68.
Yes, my lord, I appear on with the petitioner. The work order, my lord, is at page 17. 18th March.
The authority.
Yes, my lord, he is the authority.
The executive engineer, PWD.
Yes, my lord, that is at page 20. Page 20, I have raised the bill and the representation 10th January 2024. Till today, it has not been considered. That is at page 20.
Let there be a direction to consider the representation, my lord. Let there be a direction to consider the representation, my lord.
Where is the work order?
Yes, my lord, that work order is at page. That is at page 18. Page 18.
What is the 17?
Page 17.
Provisional.
Milord, that was the provisional work order. Milord, when Milord, I have participated in the tender, thereafter Milord, provisional work order. Subsequently, Milord, the 18 is the continuation part, and 19, Milord, the work completion certificate.
The grievance of the petition in the present writ application that initially the executive engineer PWD Birbhum Electrical Division, Suri Birbhum, has issued the provisional work order on 18th of March 2021, and subsequently on 17th of October 2021, the work order was regularized and the petitioner has completed the work, and on completion of the work, comma, on 9th of February 2024,
My lord,
2024, the executive engineer PWD Birbhum Electric Division has issued a certificate certifying that the work assigned to the petitioner has been completed. After the completion of the work, the petitioner has submitted his bill. No amount has been released. No
My lord?
amount is released. No. Submitted the bill, but no amount has been released. Subsequently, the petitioner has made several representations, and the representation is still pending before the authority. Counsel for the petitioner submitted. The petition will be satisfied if the petition will be satisfied if the petition is disposed of by directing the authority for consideration of the representation filed by the petitioner for release of the amount. Learned counsel for the petitioner state respondent submit that as the petitioner has filed the representation and is pending before the authority, if a direction amount release
my lord, subject to, my lord, there is a correction. My lord, if your lordship kindly come to page 21 once, page 21.
Yes.
My lord, I cannot make the wrong statement. My lord, accepted amount, it has been mentioned at the bottom, and the payment amount, that is 12,85,848 is due.
No, payment amount, bill amount. Accepted amount 6660. Bill amount
Partial amount paid, my lord, 1285 and 848 has been paid. And 49 lakhs is due.
After receipt
49 lakhs, 13,000, that is bill amount.
After receipt of the bill submitted with the petitioner, part payment has been made.
সেটা payment amount
Further amount is due. The counsel for the state submitted, the petitioner submitted representation, and if a direction is given, the respondent will consider the representation of the petitioner. In view of the submission made by the counsel for the respective parties, WPA number 21783 of 2025 is disposed of by directing the respondent number.
My lord, respondent number, the executive engineer PWD, that is at respondent number, my lord,
8.
My lord, that is, my lord,
the
executive engineer, my lord, 8. Respondent number 8.
Electrical division to consider the bill submitted by the petitioner along with the representations with respect of release of the payment of the petitioner within a period of 4 weeks from the date of receipt of the copy of this order. If the authority in respondent found that the petitioner is entitled to get the payment, the payment shall be released within a period of 2 weeks thereafter. If the authorities found that the petitioner is not entitled to get any payment, the respondents will pass a reason in a speaking order. WPN
and my lord, within period of 2 weeks, my lord, I am grateful.
Next.
My lord, I am for the.
Yes,
May it please your wait, please.
This is that matter, my lord.
Item number 5 has called on.
Oh, 5. I'm sorry.
Wrong transfer in that account, my lord.
Yes, bank
RTGS. The banks are ready. GST authority says, I don't have written instructions. Today was the day where they have to come with written instructions, my lord. That they have a proceeding against the petitioner. If they can't, my lord, then they don't have a case. And I'm sure they will not take time. They'll come and indicate, my lord.
But I pay for the respondent. We had two things. First is, I am told that on the last occasion, some document of the Yes Bank was thrown to the court, which they were supposed to hand over to my learned juniors. This has not been handed over. Number one. Number two is, hey,
I could not find the clerk.
Just a minute.
ঠিক আছে. But I'll take instruction on this. What is the effect of this? But my lord, primarily, my lord, I would like to, my lord, come back, my lord, by filing an affidavit. Why? Because now, my lord, it is under a garnishee proceeding. My lord, the CGST, I'm sorry, WBGST authorities, my lord, they have, my lord, certain claims so far as, my lord, an entity called Sai Fertilizers are concerned. My lord, garnishee proceedings have been initiated against Sai Fertilizers. My lord, 18 lakhs and odd, my lord, is payable by Sai Fertilizers to the government. Now, my lord, the petitioner who has tried to, my lord, draw a picture that they had mistakenly, my lord, transferred 20 lakhs to the account of Sai Fertilizers, which they did not intend to transfer because of putting in a wrong bank account number. This money has gone from the account of the petitioner to Sai Fertilizers. Now, I can make mistake once. I cannot make mistake twice. Well, let us not go into that because twice money was transferred. Let us not go into that. But Milord, today, Milord, we are under a statutory scheme or a statutory operation. What is the statutory operation? The government has certain tax dues from Sai Fertilizers. The government has set in motion, Milord, a garnishee action. Now, in the garnishee action, Milord, the government has issued a notice to Yes Bank that if any amount is due, I mean, lying in the account of Sai Fertilizers, withhold that amount and transfer it to us. But that is the statutory scheme. It is under where the CPC also, Milord, under the Income Tax Act, then Milord under the GST Act also. These proceedings, the provisions are common in various statutes. Therefore, Milord, today, Milord, my learned friend's client have tried to draw a very, very innocuous picture that, see, this is a mistake, it should come back to me. Now, but if an order is passed today, which my learned friend's client, Milord, has invited the court to pass, then, Milord, it would directly infringe, Milord, a statutory functioning. Therefore, Milord, give me a week's time, I'll file an affidavit, bring on record, Milord, what we have written to the Yes Bank, and Milord, Yes Bank has withheld that amount pursuant to, Milord, our notice. And the corresponding obligation of Yes Bank is to transfer this amount to us. Maybe
Yes Bank has informed you, as immediately the Yes Bank has already informed you, but you have not taken, I don't know, that's why it's in your
No, now, Milord, it's no more my obligation. Now it is Yes Bank's obligation to transfer it to me. And if Yes Bank does not transfer it to me, then Milord, Yes Bank becomes defaulter so far as I am concerned. I means the state. So that Milord, I'll bring on record. Your Lordship may take it up.
Once my learned senior has made his submissions, kindly permit me 5 minutes. I'll indicate.
No, but first is Sai Fertilizer have to be brought on record. Yeah, it has to be brought on record.
Yes, what is the submission?
Milord, yesterday, Milord, when the matter was last taken up, we have made our submissions. It's not Sai Fertilizer, Milord. A wrong transfer to the account of Sai Fertilizer doesn't make it a garnishee proceedings at all. That's absolute first principles, doesn't make it a garnishee proceeding. I made a mistake. I sent it to a wrong account. That's my mistake. That does not mean there's a deemed proceeding against me. A mistake does not tantamount or equate, Milord, with a proceeding in the GST against me, the petitioner. Sai has no relation with Jai Balaji. If they can show that Sai has a relation with Jai Balaji, that is also not sufficient. What is at most important for them to show is that there is a proceeding against Jai Balaji, a notice or a proceeding against Jai Balaji, and that was that also at that point in time. Today, if they initiate something that is immaterial, there is nothing that is due and payable by Jai Balaji to the GST authorities.
Yesterday out there, yesterday, this court is of the view because see, Jai Balaji, the Sai Fertilizer has given a letter to the bank. Yes, he has not connected.
He is not connected.
It may be written.
Not connected.
Okay, no problem. But let the Sai Fertilizer come and file an affidavit in 2 lines. It has been mistake. It is not my amount because now the GST authority has come in picture. If the GST authority has come in picture, if it is in inquiry, if it is found that the Sai Fertilizer only to avoid his liability has given the letter, let he file an affidavit before the court. Yes, this is not my amount. I have no liability on that amount.
That's what I understand what is falling from your Lordship. My Lord, subject to being corrected by your Lordship. But may I submit this? Today, my Lord, let's visualize a situation where Sai Fertilizer doesn't come up, doesn't give an affidavit.
That's why if
But
it's
today,
not,
if this is a
if
situation,
they will not, if will not come, then the S Bank, I will also ask the S Bank to file an affidavit disclosing all the document before this court.
may I only make a minute submission, my lord. Today, my lord, if the bank says that there is nothing which is amiss, it's a genuine, my lord, mistake by our part,
Correct.
on our part. Sai fertilizer is not a necessary or a deemed party, my lord.
There is
Today,
no-
I'll indicate why. Kindly bear with me for
There
30
is no
seconds.
question, Mr. Bhag,
My lord.
for giving any impression upon you that you have mingled with the Jaifal
Indeed, my
thing.
lord, indeed.
Okay. Only now the court has also to be inquired whether it is perfect, it is by mistake, or it is the amount, but it is the Sai fertilizer wanted that his liability is to be go and the amount is returned to your account and you can utilize.
If it's falling from your, my lord.
If the Sai fertilizer will come and file an affidavit stating that I have no liability in this account, this amount is not me, and the S Bank also filed the document immediately we have informed and he has given that, then let the GST, what the GST will take is that then the court will decide it accordingly.
Today, all that I want to submit, it can't be, my lord, in the, my lord, in the farthest of, my lord, the arguments which can be proposed, my lord, submitted before your lordship, that it's a garnishy proceeding. Can't be, my lord. Can't
That's
be.
why they may take anything. The court has to decide.
Indeed. my
And
lord,
if
indeed.
they are taking any steps, if they're taking any steps, let it come on affidavit what they want to say.
All that we are waiting for, my lord, is an instruction, a fair instruction from the GST authority.
Correct.
They come and say this is not against Jai Balaji.
No.
That's
Today,
all
my
that
lord,
we are
I'm making
praying
a
for.
statement. We have no proceeding against Joy Balaji.
That is, that kindly record that. That's all that is, my lord. If they have no
But the
proceeding,
proceeding
yes.
is against Sai.
My lord, so far as I am concerned, I'm representing the banking ombudsman. On the last occasion, I had indicated that when a complaint was lodged with Reserve Bank of India Banking Ombudsman, we immediately took it up with the Yes Bank. Yes Bank, being the regulated entity, had informed us that yes, the amount was wrongly transferred, and that was also informed by the concerned banker, concerned account holder, in whose account the
The
money
amount was
was
deposited.
wrongly remitted. Now, under the circumstances, if it is also admitted by the authority concerned today that yes, there is no proceeding, and whether this amount, because the proceeding was initiated in 2023, which was submitted by the learned senior friend on the earlier occasion, and the money has been remitted much later in 2025. So, in such circumstances, when there was an order to keep in hold with regard to an amount of 18 lakh and odd, and the transaction is of 25 lakh and odd, that is the general question which crops up in my mind, and I pose the question to myself, to the amount in excess of the amount which has been requested by the GST authorities to keep hold of, the rest should be disbursed immediately. There shouldn't be any hold with regard to the amount in excess of the amount which has been asked to be kept on hold. So 18 lakh and odd, rest should be allowed to be transferred subject to what falls from your lordship, because if it commences to your lordship that yes, all parties should come up on affidavit, but then also a question again comes to my mind that because Sai Fertilizer is not interested and he has actually indicated it in writing to the concerned banker, and the banker has also brought it to the notice of this honorable court, how far Sai Fertilizer would be coming in this proceeding, how far Sai Fertilizer is at all going to come and represent, is also another question which has to be considered. So any amount, till such time the concerned authority comes up on affidavit, and Yes Bank also comes and files an affidavit, the amount which is in excess of the amount which has been asked to be kept on hold may be released. That's all I can make my submission, considering the fact that I am representing the banking ombudsman before whom the complaint was lodged initially.
Okay. Yes. Yes, Bank. So you do one thing, you file all the things. By how soon you can file affidavit? By disclosing all documents. And how soon you will file affidavit?
1 week,
we'll file in 3 days?
Yes.
We'll file in 3 days, my lord.
3 days.
Lord, may I only pray for this?
Here, my client doesn't wish to use any affidavit
No,
because
you are clear because it is only them. That's why the court wanted to examine what is the actual, what the GST authorities claims, whether it is coming and whether the GST authority can claim that amount.
Yes. The hold was to the extent of 18,49,237 pursuant to the order of 27th of March 2022.
Yes. Lord, may I only pray for this indulgence?
Yes.
Lord, in the meantime, Lord, if there's a direction on Yes Bank, Lord, for the balance amount to be transferred to the petitioner, Lord, which is not an issue at all.
What is the total amount of the claim of
25
the
lakhs.
GST?
Ours is 18 lakhs and odd. 18 lakhs 49,237. I do not know whether any interest has accrued on this amount or not. Some interest must have accrued by this time.
For us, somewhere, my Lord, we are not really at all at fault.
No, we are not pointing fingers at the petitioner. We are saying that it is our money.
The learned AG submits that the GST authority is required to file and prays for time to file affidavit. Let affidavit in opposition file affidavit, full stop. This court find that the Sai fertilizer in whose account the amount has been inadvertently transferred has given a letter to the Yes Bank that the amount not belongs to the Sai fertilizer. On the basis of the said communication, Common Learned Counsel appearing for the Yes Bank has submitted before this court that if this court will pass and submitted before this court that the Sai fertilizer has informed that he has no objection for remitting the said amount in the name of, in the account where the amount has been transferred. Full stop. This court finds that though the Sai fertilizer has given a letter to the Yes Bank giving no objection for remitting back the amount from the account where the amount has been transferred, in the account of the Sai fertilizer. But the Sai fertilizer is not a party in the present date application. This court is of the view Sai fertilizer should be made as a party to the present date application, and he should file an affidavit stating that the amount will not belongs to him. Full stop. Accordingly, the petition is directed to implead the Sai Fertilizer Private Limited. What is the name? Sai Fertilizer
Private Limited.
As respondent number 14. How soon you will do, Mr. Bag?
Yes.
By tomorrow? By Tuesday?
With the service. We'll do it by Tuesday.
Okay. Today you can implead them.
We will implead them. The details of the party is required to be given by Yes Bank.
GST or Yes Bank?
Either GST authority or Yes Bank.
You are having at present the details. How soon you can give?
Nothing more.
Or GST authority might have having.
But I'll try to get it and give it. I'll try.
When? How soon? Because he has to implead then.
I'll try to give it by today itself.
We will carry out the amendment today itself, with the leave of the honorable
course of the day, subject to the details is provided by either GST authority or the Yes Bank. After impleting the Sai fertilizer as party respondent, the petitioner serve the copy of the writ application along with the document to the Sai fertilizer. The Sai fertilizer is directed on receipt of the writ application shall file an affidavit only to the effect whether the amount received in their account belongs to Sai fertilizer or not, and whether he has given no objection to the Yes Bank of India that he has no objection for remittance of the said amount in the account from where the amount has been transferred. The Yes Bank and the GST authority let the said affidavit be filed within a week from the date of receipt of the writ application. The GST authority as well as the Yes Bank is also directed to file affidavit by today we are on 14. By 20 affidavit by 20 after serving the copy to the learned counsel for the petitioner. The petitioner liberty to file reply by 25th, list the matter on 26th.
But kindly make it 21st, instead of 20.
21st, reply by 26th, place the matter on 28th under
Friday,
the
next Friday.
heading adjourn motion.
Good.
Yes, but file a report in form of an affidavit
Affidavit.
closing club.
Your lordship is pleased to, my lord, keep it on 26th, my lord.
28. By 25 until 21st, the GST and Yes Bank will file,
My lord.
and the private and the added respondent.
Lordship.
And 26 you file reply.
We'll do that.
28 at adjourn motion.
Would it be your lordship's pleasure, my lord, to fix any time, my lord?
Adjourn motion need to come up. Okay,
If-
adjourn motion at the top.
At the top. I'm very deeply obliged.
And we recording.
Lord, may this submission be recorded, my lord, because my learned senior friend has just submitted that there's no specific proceeding against the petitioner. Only this much. But I am sure.
In respect of this particular issue.
Learned
Indeed.
Advocate General the learned Advocate General in his fairness submission submitted that at present there is no proceeding against the petitioner before the GST.
Concerning this amount.
I'm very deeply obliged.
With regard to the amount in question.
Very deeply obliged, my lord.
I'm grateful.
My lord, I humbly request my lord to recall the order. Item number 13, my lord, has been dismissed for default, my lord. It's a very small matter, my lord, can be disposed of, my lord. But I pray for recalling of the matter, my lord. Item number 13.
Persons are not appearing when the matter is called.
But I was on lecture court number 8, my lord.
Only you are appearing, only single in your
My lord,
temper.
state is also appearing. I shall intimate the state, my lord, and shall come back at 2 p.m. or any date, 2 p.m., my lord, kindly.
But dismiss for default का कौन order लिया?
Item number 13.
13. Item number 13.
Yes.
Come with the other side. I will see.
Yes,
to
my
that.
lord. At 2 p.m. I shall come with the others.
Come. Yes. Call the matter.
May it please your lordship.
Yes.
I beg to appear on behalf of the writ petitioner. Now that here the peculiar feature is the petitioner and the private respondent. Now both of them contested the panchayat election. The petitioner contested on behalf of the party in opposition, being the Bharatiya Janata Party, and the private respondent from the ruling party, that is the Trinamool Congress. Now the private respondent was then elected as the Pradhan of this particular Gram Panchayat on the strength of an OBC certificate. It was reserved for OBCs. Now thereafter the petitioner gathered information, made necessary inquiry. He had been writing to the authorities that it's a fake OBC certificate. This private respondent is not a OBC. But there was a deaf ear which was lent. Finally, my lord, the doors of justice were knocked by way of filing the previous writ petition. My lord will find the order at page 31 of the writ petition. We moved the residuary court seeking for cancellation of the fake caste certificate issued to the private respondent. So my lord will find it at page 31.
Yes.
Yes.
On conclusion of the inquiry, fresh reason order shall be passed and communicated to the parties. If it appears the allegation of petition is proper, necessary remedial measure may be taken up.
Yes. Now, initially what happened was the state had submitted a report before her ladyship stating that, no, we find that the OBC certificate is genuine. But the inquiry which was contemplated, which is contemplated rather, my lord, under the act, that was not done. So thereafter, her ladyship in this order only directed the inquiry to be as contemplated, but not to be done under the West Bengal SC and ST identification rules 1995. Because, my lord, for OBC, there are no separate rules. On the strength of, my lord, office memorandum, the provisions of the SC/ST Act and rules, my lord, that has been made applicable. My lord, my junior has that memorandum dated 27/7/2015, my lord. My lord, kindly takes, my lord, clause 1. So clause 1 makes the SC/ST Act and rules applicable vis-a-vis OBCs also in the state. It states that there is no act regulating identification of persons belonging to other backward classes. The relevant procedures and provisions applicable for identification of SC and ST as entailed in the SC/ST Identification Act and rules framed thereunder will be applicable for identification of OBC persons, mutatis mutandis, with appropriate modifications. So her ladyship directed, my lord, action under this particular, under the provisions of, my lord, the act and the rules. Now on the basis thereof, the authority, my lord, the SDO is the authority. He caused an inquiry. My lord will find the inquiry report at page 42.
Yes.
The inquiry report reveals that the private respondent belongs to the Gotra Shandillo. Now, my lord, Shandillo Gotro is a Gotro which is available. My lord, these are known as, my lord, the general Gotras, my lord, that is Bharadwaj, Shandilya, Kashyap, and my lord, Sabanda. So Shandillo is a Gotro, one of the Gotros, exclusively for persons belonging to the general caste. And the inquiry report revealed, Malad kindly takes the inquiry report at page 42, the third paragraph and onwards. It states that on being asked to provide any supporting documents on the basis of which the said OBC certificate was issued, Srimati, the private respondent, could not provide any such documents. She only provided the document of her family tree and legal heir documents of her father, such and such, issued by the Pradhan of such and such Gram Panchayat. As such, a field inquiry was conducted jointly by the BDO, Joint BDO, Inspector in charge of Chandipur Development Block, and it is found that people living in the locality mainly belongs to the Mahisho subcaste community. Her mother also belongs to Mahisho community before marriage. Various people in the area, including her family member, were questioned, and from depositions it appeared that the clan, that is Gotra, of the certificate holder was Shandillo before marriage. In conversation with other kith and kin, it is found that their birth, death, marriage rituals, and observation of religious festival are like Mahisya subcaste. The main profession of the said area is hair processing, and nothing substantial could be affirmed regarding the profession of the ancestors of said Khukurani Mondol. However, Khukurani Mondol Gorai has also given a written deposition in the form of an affidavit in front of first-class judicial magistrate that their ancestors belong to OBC caste. In the absence of any specific document that could establish her caste as OBC, that is Tanti Tontubai, that is weaver, my lord. Persons who are into, my lord, the business of weaving. And on the basis of their current profession, rituals, gotra, the claim that the incumbent belongs to OBC could not be established. Hence, it appears to the undersigned that the incumbent does not belong to OBC. So thereafter, my lord, it was placed, my lord, to the certificate issuing authority, my lord, being, my lord, the subdivisional officer. So, my lord will find the order of the subdivisional officer at page 44, my lord. This is an order dated 23/7/2025.
Yes.
So the SDO records everything. The SDO records that despite opportunities, the private respondent has failed to produce any document. The field inquiry report was also, my lord, relied upon. Finally, my lord, what is being done to protect, my lord, this politically influential private respondent? The last paragraph, the penultimate paragraph, my lord. The SDO says, after hearing all parties and perusal of the report submitted by the BDO Chandipur, it is concluded that Khukurani Mondol Gorai does not belong to OBC community subcaste Tanti Tontubai. So he returns to a finding that she is not an OBC, but he does not deliberately take any action to cancel the OBC certificate because she belongs to the party in power and she is illegally assuming the office of the Panchayat Pradhan, my lord, which is exclusively reserved for the OBC candidates. We have in fact, my lord, also issued, also annexed, my lord, at page 50, documents showing that even despite passing of this order, this was passed in July, now this is of August, my lord, this private respondent is still acting and functioning, my lord, as the Pradhan of this particular Gram Panchayat. Now, my lord, coming to the legal provisions.
So whether that
my lord,
the post of Pradhan was only for the OBC?
Yes. But we have also pleaded that also. It was reserved for OBC. And in any event, my lord, my grievance is, my lord, that despite returning to a finding that she is not an OBC, the certificate issuing authority has washed its hands off, my lord, which is again
and
an action.
Private respondent has not challenged this order.
My lord, the private respondent filed another writ petition. The private respondent filed another writ petition. This was again another, I'll say, my lord, another coup, which was engineered by and between the state and the private respondent. So upon filing of the writ petition, the private respondent goes up before the Honorable Justice Sinha and says that this is a panchayat matter, not a residuary matter, release it. Thereafter, the matter gets listed before the Panchayat bench. So the private respondent once again goes up before the Honorable Justice Vibhash Patnaik and says that no, I was under a mistaken impression. This is actually a residuary matter, not a Panchayat matter. Therefore, please release it. So, citing pendency, they do not want to give any effect, my lord, to this particular order. My lord, insofar as, my lord, the law is concerned, Section 5 and 9 of, my lord, the Scheduled Caste and Scheduled Tribe Identification Act 1994. But these are, my lord, the relevant provisions. 5 says, my lord, that the certificate issuing authority, Onish, can you please hand over the book to his lordship?
Yes.
I have handed over.
I'm grateful. So 5 speaks about, my lord, the authority concerned. So, my lord will see, my lord will find 5 subsection A. It's the subdivisional officer of the subdivision concerned in case of district, my lord, who issues the certificate. And thereafter, if my lord kindly takes pain to, my lord, kindly take section 9. Section 9 provides power to cancel, impound or revoke certificate. So 9(1) says, if the certificate issuing authority is satisfied that a certificate under this act has been obtained by any person by furnishing any false information or by misrepresenting any fact, or by suppressing any material information or by producing any document which is an act of forgery, it may cancel, impound or revoke such certificate in such manner as may be prescribed. But this action, despite, my lord, the Honorable Court also ordering, my lord, directing specifically in the previous round of litigation to take necessary steps if it is found, my lord, if my claim was proved to be, my lord, genuine. This has delivered.
Where is the writ application of the private respondent?
My lord, I am representing the private respondent number 7. The fact is not, in particular in West Bengal Mandal Commission issue implemented at that time.
Where is your writ application?
No, that writ application 10,033 of
No.
2025.
20033 probably.
10033 of 2025.
When you filed?
20033 probably. According to the writ petition also, and I have checked the orders. 2020 no? It's 200.
200. 10 লিখেছে কেন?
এটা মেনশন করা হয়েছিল এই কোর্টে আছে এরকম।
But kindly takes the 2 orders, my lord, will appreciate, my lord, the mischief
I have handed
which
over.
has been resorted to, my lord, by the private respondent.
Both the matters should be heard, the analogous matter, and I am appearing for the private respondent. The certificate issued by the SDO earlier is genuine. As per the application, there is a spot inquiry, এবং there is a government notification. That notification already properly maintained. Afterwards, after local inquiry, the OBC certificate issued, and that particularly the Mahishya committee, his mother, Mahishya now is included in the Chashi Koibotto in the state list. And lot of litigation, and my lord, this is the implemented in 93 or 94. The first 64 at the division bench declared at the minority commission. My lord justice.
That is correct. Declaration, there is
No,
nobody
this
challenge.
is the
Where is the document you produced before the authority?
that document is already but the lying with the SDO office.
But the SDO stated
that certificate when he issued and the proper inquiry and as per the government notification, the only when the
okay,
proper.
you do one thing. Well, I am putting your writ application along with this, and if this your writ application will be treated as a written the affidavit of this writ application, your writ application, and this writ application, your affidavit in opposition, I will dispose of those.
And will supplement affidavit.
What supplementary affidavit for
their reply?
I will treat both application as an affidavit and dispose of, nothing else. This is the election matter. So
Lot of documents as per government notification. The certificate are issued.
You disclose all the things in the affidavit in your writ petition.
No.
In the writ petition, we find, my lord, in their writ petition, what they have done is once they found that the result is not going to be palatable, they have manufactured documents to the extent of also, my lord, that I was traveling.
Motivated,
I have suddenly lost the bag containing relevant documents. It was diarized before the police station also, and we find, my lord, backdated documents also. This is apparent.
For the state, my lord. As far as the writ petition, which is not on list today, which is by the private respondent, my lord, their contention is probably, my lord, I am not briefed in that. But as far as I understand, their contention is going to be that why my findings of 25th of August, I'm sorry.
23rd July.
Yes. 23rd July should not be set aside. On which the writ petitioner says that the findings of 23rd July have been arrived at, so next action should have been taken. Milord, a submission was made, Milord, that the state authorities are in cahoots with the respondent. That is not true. However, what has been submitted by the learned senior counsel for the Milord petitioners today, I do not as such dispute on the facts or the law, but may I, with your lordship's leave, just only explain that there seems to be a confusion. Otherwise, Milord, this allegation should not, or I believe should not be have been made. Milord, may I just place this? Milord will kindly take up Rule 3 of the rules.
Rule 3 of the?
Of the rules which was handed over to your lordship.
Mr. Bose, I am yet to exhaust myself. I am to rely on my two decisions also.
No, that's
To-
Yes,
no,
yes.
Mr. Bhattacharya, because
Milord, I only
the
seek to.
petition
Yes.
is already there.
Yes.
I am not going to.
Very good, very good.
Prima facie, I have the view that that application be listed together.
Yes.
Both the
Yes,
matters.
yes.
Only to Milord, intimate this honorable court how my officers has understood the provisions of law. Otherwise, Milord, whatever the petitioner has said, I have no qualms against that. But probably we view this in a different way. Milord, kindly comes to 3.
Section rule 3.
Yes, Rule 3. 5 was cited before your lordships.
Yes.
I'm sorry, my lord, section 5 was read out to your lordships. I invite your lordships attention
Relying
to
upon rule 3.
Rule 3 of 1995 rules,
1995.
which my lord lays down the procedure for cancellation, impounding, or revocation of certificate.
My lord, perhaps that book's.
Yes.
May I hand over?
This book
May I hand over?
carry the rules.
May I hand
It has
over?
only the act, my lord.
Lord, I have opened it to the my lord, first page of the rules.
Rule 3.
Yes, my lord. Rule 3 of the West Bengal Scheduled Caste and Scheduled Tribes Identification Rules 1995, which my lord prescribes the procedure.
Yes.
Now, my lord, may I read there from 3.1 says, whenever it appears to a certificate issuing authority on complaints by any person or suo motu that a person in whose favor a scheduled caste or scheduled tribe, here it will be OBC, certificate has been issued, does not belong to such caste or tribe, the certificate issuing authority shall hold a preliminary inquiry by itself or by any officer above the rank of inspector of the scheduled caste and tribes welfare department as may be authorized by it in this behalf, and shall prima facie satisfy itself on the truth or otherwise of the complaints as aforesaid, record the reasons of its satisfaction as to the truth or otherwise of the complaints, and if necessary start proceedings for cancellation, impounding, or revocation of the certificate as the case may be. So, my lord, first is, my lord, preliminary inquiry for satisfaction that prima facie it does not appear.
Correct.
Thereafter, my lord, what happens is Rule 2, where any proceedings have been started under Sub-Rule 1, the certificate issuing authority shall by written notice ask the person holding the certificate to deposit the same.
Correct.
Next step is you deposit it.
Correct.
Thereafter, my lord, 3, the certificate issuing authority shall then issue a notice to the holder of the certificate to show cause within 15 days or within a period of shorter duration as it may think fit as to why that is a show cause, why it shall not be consent. So, my lord, first is, my lord, further may not be necessary for this purpose. First is prima facie satisfaction. Second is issuance of letter to submit your OBC certificate. Third is show cause.
For this rule, the first has been completed.
Yes.
Inquiry has been done.
Yes.
Now
The second remains.
Yes, with regard to the deposit of the
Yes, that has been done. That has been done.
That has been done.
That has already been done. My lord, the confusion arises. Why I say, your lordship, is the first preliminary in the rules, though the contemplation of hearing the parties has not been made, but it had to be done because of the order passed by the my lord honorable single judge that hear the parties.
That's it. That is the
Yes.
stance of the writ petition.
Yes. So, my lord, we are not in cahoots with anybody.
So when,
My lord,
when she has surrendered the certificate
no,
before the
my lord, the notice to issue surrendering certificate has been issued. I will give your lordships the date.
Correct.
The exact date of the notice, my lord, is 28th of August 2025, my lord. This I say by reading from the, my lord, relevant report which has been, my lord, handed over to me by officers, number 1. Number 2 is, my lord, thereafter we have not proceeded, my lord. Why? Because there are two contradictory, my lord, writ petitions. One effect to 27th. 23rd order, the other challenge is the basis of the 27th order. We have, my lord, thought it prudent, my lord, to stay our hands for some time so that, my lord, we get an observation from the court. If the basis of our order remains, we will have to proceed. Okay. If it is set aside by your lordship, my lord, then probably we will not proceed anymore, or we will just abide by the directions.
My petitioner was not present and expiry order was passed by the
Yes. That is all.
last court.
That is all for now to explain my conduct.
My case is that regarding as per Mandal Commission issue, he is the genuine.
This your
and
writ petition. I am keeping this writ petition along with your writ petition. When both all the parties will be available, so the matter can be heard it out.
Kindly, my lord, fix it on Tuesday, my lord, as an adjourned motion.
Next week.
Tuesday or Wednesday?
Any day, my lord, as per your.
My lord, may I also, my lord, two things, my lord. If your lordships are pleased to direct the private respondents, my lord, to serve the concerned advocate for the state of this notice. I will also do this, but let, my lord, that this petition is going to
Yes,
be taken up.
you have not served the copy.
No, the notice to the learned advocate appearing for the state. I will also do it from mine end.
I am the
Mr.
Lord,
Bose is there. He is the
Aman
junior
Banerjee.
standing counsel. He can appear in
I
all the
will do
matters
that. I
of
will
the
do that.
state.
I said I'll do that from my end, but
And
let
I am
that also be
grateful.
said.
I am grateful to Mr. Bose, my lord, that he has submitted that we have not proceeded owing to pendency of the writ petition. So, my lord,
Yes.
my lord, it now meets the logical end, my lord, to my submission as to why they were getting their writ petition released from various courts, my lord.
That is
I'm grateful to your
private
lordship, my lord.
respondents, my lord. We do not.
I'll argue on
And
that.
my lord, may I, my lord, take your lordship's leave, my lord, for
As per
that.
procedure
Grateful to your
certificate
lordship.
issued and this is genuine. Now in the political motivated, they are already challenging to cancellation of the caste certificate, nothing else.
That concern with the order, in connection with the order dated 23rd of July 2025, passed by the divisional office, sub-divisional office of Tamluk, Purva Midnipur, another writ petition being WPA 20033 of 2025 is filed by Srimati Kakurani Kukurani Mandal Gohari. By an order dated 29th of October 2025, the matter has been released on the ground by the coordinate bench of this court. On the ground, the matter pertains to Group 9. Accordingly, this court is of the view that the present writ application along with WPA 20033 of 2025 with the precedent Kukurani Mandal Gohari versus State of West Bengal shall be heard along with WPA number 21813 of 2025. Let both the writ petition be placed before this court on 19th of November 2025 under the heading adjourn motion.
My lord, last time Justice Amrita Sinha, the private restaurant not was present.
You saw the notice, the record. The counsel for the writ petitioner number WPA 20033 of 2025 is directed to serve notice to all the respondents.
I'm the private respondent. I am here only. I'm the petitioner also, so I'll be present.
Let this have
Very well, very well, very well.
serve all the respondent by indicating the date of hearing on 19th of November 2025 and to file the affidavit of service on the next date fixed. You saw the notice? 19th. You saw the notice today itself. Come on 19th, the matter will be heard expeditious. File the affidavit of service.
Extremely grateful to your lordship.
Can be kept with that.
Grateful, my lord.
Saw the notice today itself.
Yes, my lord.
Yes, next.
No, I'm appearing for the Mr. Gupta is there online.
My lord, I appear for the petitioner, my lord. The petitioner, my lord, is the petitioners are, my lord, purchasers, or rather, my lord, they are, my lord, lessees in respect of, my lord, flats, which are, my lord, in respect of a housing project of, my lord, Asansol Durgapur Development Authority. My lord, what had happened is,
Who is
despite
appearing? Respondents?
The state is not a party. The Asansol Durgapur is Development Authority is a party, and I am appearing.
Asansol and
Asansol, there are two respondents. One
Yes.
is the developer engaged by Asansol Durgapur. The
Yes.
other is the Asansol Durgapur. But there are two respondents.
What is your prayer?
One of the petitioners are basically caught in the crossfire between the developer and Asansol Durgapur. But despite having paid the entire consideration, my properties are not being registered by the respondent. And they are putting blame on each other. And I am the one who is caught in the crossfire. I have paid the entire money. There is no allegation of any default from my end.
Who is the authority? Who is the authority? One.
Yes. The respondent number one. But if they have any claim,
Yes.
against the developer, but this is a project I have applied for this project only on the ground that my lord, this is a private-public partnership. But if your lordship is pleased to take a look at, my lord, the brochure, kindly takes a look at, my lord, page.
Just a minute. What is your stand?
Lordship, I take a preliminary objection that this is in effect a decree of specific performance being sought in the guise of a mandamus. In that respect, my lord, I have a preliminary objection.
Yes, argue the preliminary objection.
My lord?
Yes, argue the preliminary objection first, then I will take the call from the respondent.
My lord. And if I submit on the merits, my lord,
If you are taking the preliminary objection, you
Judgment,
argue first on the ground of preliminary objection.
Lordship kindly takes up, Lordship. This is reported at 2022 Ford scale to 280.
Yes.
Lordship kindly takes up the internal, it's paragraph 2, 2.3 at page 2.
Yes.
Here also, my lord, the respondent was a state authority. And my lord, writ petition was filed and decree of mandamus, my lord, was sought for specific performance. Kindly take, my lord, I'm reading out from paragraph 2.3. That why the order dated such and such, and Noida rejected the said representation, feeling aggrieved and dissatisfied with the order passed by Noida dated such and such. But the next line is relevant. The High Court, by impugned judgment and order, has dismissed the said writ petition inter alia, holding firstly that writ petition arising out of a contract between parties is not maintainable, and the petitioner should have filed a suit for specific performance. Secondly, writ petition has been filed after delay of 16 years. I'm not getting into it. My lord, now, my lord, I rely on paragraph number 6, the second last paragraph.
Yes.
Even otherwise on merit, also, we are in complete agreement with the view taken by the High Court. The High Court has rightly refused to grant any relief, which as such was in the form of specific performance of contract.
Yes.
No writ under Article 226 of the Constitution of India shall be maintainable or entertainable for specific performance of the contract.
Show me the record. Show me the record. Where is the agreement? Where is your denial?
My lord.
What is the fact? Show.
But fact is that this is
show from the record.
all
sir.
documents are not here. The petitioner has filed it, my lord. I'll have to file an affidavit because the agreement is not there.
If you want to file affidavit, first you are raising the mentality what type of the submission you are making, sir? You are stating that the mentality relied upon the judgment. This judgment, I think the learner also knows. The writ court cannot pass an order under the Specific Performance Act. You show the facts. Yes, this is covered under the said judgment. What the document is required? If you are challenging the mentality of the writ application, from the writ application you have to show.
My lord,
Which document you are relying upon? This is a contract.
My lord, there is an information brochure on basis of which the petitioner makes an application to the private partner named Shugam Park, but it is an association of persons. Association of persons has not been made a party herein. Only the name of the business has been made up, as in my lord, as the parties. Thereafter, my lord, an allotment letter has been given.
By whom?
By the.
Who are you?
My lord, I am the Asansol Durgapur Development Authority, which is the public partner in the project.
Public partner of the project.
In the project.
And respondent number 2.
Of the respondent number 2.
Correct. Who has issued this brochure?
Brochure was issued by the private partner, taking, my lord, the consent of the public partner. Thereafter, after the brochure was issued, the petitioner applied, my lord, makes an application, and on basis of the application, allotment letter was given.
By whom?
By the private partner.
2.
Thereafter, my lord, after the allotment has been given, now the petitioner comes and seeks enforcement of the entire thing. So,
any agreement between the respondent number 2 and the petitioner?
My lord, my submission will be that the application is an offer and the allotment is an acceptance.
Correct.
So,
what is to be registered by you?
The lease deed.
Where is that lease deed?
My lord, lease deed has not yet been registered.
Where is the lease deed? Between whom?
lease deed, it's the land belongs to ADDA. So once the allotment has been done, the process is that the private partner and the public partner, they together forms a tripartite lease deed with the intending purchaser. This is what the process is. And that, my lord, the petitioner seeks for execution of that lease deed.
That's a show. Where is the lease deed?
Is it had not yet been executed? That is what the petitioner seeks for.
My lord, may I, my lord, indicate, my lord, if your lordship permits? Yes. Yes. But I knew that this would be the objection which they would come because they really don't have anything on merits, my lord, to object. Kindly comes to page 20 of the writ petition.
Page 20.
20.
Yes.
Well, kindly see, this is whose information brochure.
Correct.
Kindly see at the top right, form numbers ADDA. That is, my lord, the respond number 1. At top right, my lord. Then kindly sees towards the right side, it's being developed as a PPP project, public-private partnership project between ADDA and Sugam Park. On the right hand side. On the right hand side, your lordship would see after the building, the photograph of the building, where your lordship on the right hand side would find. Being developed as a PPP project. Has your lordship got it, Mulad? And Mulad, at the bottom, page 20. Page 20.
Yes.
On the right hand side, Mulad, there's a rupees 500 written.
Yes, 500.
Just below that, Mulad. Being developed as PPP project.
Yes.
Between kindly marks, Mulad, ADDA
and Sugam Park.
And Sugam Park. Kindly sees Asansol Durgapur Development Authority is also mentioned in the brochure at the bottom.
Yes.
Their brochure. Kindly turns to the next page. Kindly sees the introduction. Page 21 top.
Yes.
The government has set up Asansol Durgapur Development Authority for planned integrated development of this region. ADDA was established under the West Bengal Town and Country Planning Act. Then will it, what is the next paragraph? Acting as a change agent for infrastructural growth, technological advancement, ADDA is entrusted with giving a shape to a host of industrial estates, growth centers, and industrial and residential township. Correct. It's a township which is being developed by ADDA.
Correct.
Kindly skips a few pages. Kindly comes to page 24.
Yes.
Serial number 7, you lordship would find the rates mentioned. Then kindly sees towards the bottom of the page, in whose name I have to issue the draft. The application money. It's in the name of Asansol Durgapur Development Authority.
No, all the above payment is to be made to Sugam Park.
Sugam, yes. Application money. I was only on application money. It has to be made in the name of Asansol Durgapur Development.
Correct.
Then Millard will kindly turn to page 29. And there's a small table at the middle of the page.
Yes.
Serial number 2. After that, Millard, application money in the name of Asansol Durgapur. Then kindly sees the lottery would be done by ADDA. Kindly comes to page 33.
The application procedure, non-refundable. Okay. Then
yes. Kindly sees page 33. It is by a lottery. It's not a public contract. It's not a contract which I have entered into for purchasing any flat. It's a housing project by an authority, by the Planning and Developing Authority under the West Bengal Town and Country Planning.
Where?
Page 33 kindly sees at the middle of the page, there's a heading mode of allotment.
Mode of allotment, yes.
May I place that? The allotment of the flat to the applicant shall be done by draw of lots within 2 months from the last date of submission of the application. Venue and the time of the same will be intimated by public notice, including notice on official website of ADDA.
Correct.
Then kindly sees there's a terms and conditions of allotment. Kindly sees the 5th bullet. The allottee is not entitled to transfer the allotted property or any portion thereof in any way without permission of ADDA in writing.
Correct.
So they are controlling everything, right from application to the lottery to what I would be dealing with. Kindly see the next page, page 34. Kindly see serial number 2 at the top. The terms and conditions of ADDA, including the terms and conditions regarding making payment of transfer fees, etc., if any, as may be prevailing at the time of allowing the transfer are complied with, the ground rent may be assessed by ADDA in accordance with the provision of the lease deed. Then my lord kindly sees the next heading, execution of the lease, on the same page, the second bullet. After payment of the entire lease premium and other amounts and deposits and fulfillment of the terms and conditions of the allotment, a tripartite lease deed as per the decision of ADDA will be executed in favor of the allottees. My lord, we are stuck here. We have made the entire payment. We are stuck here. Kindly sees there's a small box after that. ADDA reserves the right to reject the process of lottery or result thereof at any time whatsoever without assigning any reason there. So, the entire process, as your lordship sees, it is controlled by ADDA.
Correct.
It's not really any project which comes up where I go to purchase a flat. It's a housing project of a state authority.
Okay, whatever it may be, but after payment of the entire lease premium and other amount, the deposit and the fulfillment of the terms and condition allotment, the tripartite lease deed. If the lease deed is not executed, how the writ court can go into?
Yes, my lord, now I am backed by 2 or 3 judgments on this issue, and specifically on this exact issue by a coordinate bench. I think Mr. Kedia is there. If you could hand up the judgment of Justice Bhattacharya, please. But if my lord is pleased to take a look at this judgment in the matter of Vinod Kumar Agarwal.
Yes.
My lord, here, my lord, the authority was WB Hidco, and my lord, the developer was Shapurji Palon. My lord, here, my lord, Hidco had taken the point of maintainability on the ground that this is really a specific performance in the nature of a writ petition.
Correct.
So, my lord, this would not be maintainable. My lord, that point was decided against, and the ground on which the writ petition was found to be maintainable is because of the nature of the project. Where, my lord, the state authority comes, and my lord, it is looking at the state's involvement in the project 1 applies. Kindly see, my lord, paragraph 1, where the maintainability issue is raised, my lord, that has been noted. Then kindly sees.
Okay.
First is paragraph 1, where the issue is noted, my lord, on the ground of maintainability. Then my lord will kindly have the at from page 6. In fact, my lord, page 5, the last 2 paragraphs, it starts with the cause of action of the present writ petition. Has your lordship got it?
Yes.
Page 5. Yes. The cause of action of the present writ petition is comprised of a sequence of events and agreements. The first is a development agreement dated such and such entered into between Hidco and Shapurji Palonji, which is a public company not being an instrumental of the state. The salient features of the same are to be examined for the present purpose. Then, my lord, all clauses where, my lord, Hidco is getting involved have been noted that it is a, my lord, an LIG project, and my lord, the allotment would be done by Hidco. Those are, my lord, noted down. Now, some were similar to ours. Then, my lord, we'll kindly have a look at page 7.
Yes.
Pursuant to the application of SPCL, it was allotted to the residential plot for development and construction of dwelling house units for LIG and MIG, same as ours, LIG and MIG, for implementation of a mass housing scheme, same as ours. Hidco's obligations are stated in clause 5, subclause A, which provides that in no uncertain terms that until the completion of mass housing project, the possession of the said land by SPCL shall not be exclusively but jointly with Hidco. But here also the lessee is ADDA. So they continue to control the land, they own the land. Importantly, then clauses have been set out. Then kindly turns to page 8, last paragraph. In a word, the entire agreement speaks of SPCL to act as the developer or agent of Hidco for the specific purpose of implementing the government scheme of providing affordable housing to the LIG and MIG people. The argument of privity of contract between SPCL and Hidco is neither here nor there, since the agreement between them clearly reflects that the very purpose of the agreement to be implementation of government scheme to provide housing to lower income group and middle income group sections of West Bengal. The clauses thereof, as indicated above, are sufficiently germane to elucidate that the very purpose of the project is in public interest. The above clauses clearly show that the control and liability of HIDCO, including possession of the land, is retained till the end of the project, which can only culminate in its natural course upon handing over the houses to the target group of allottees. The respondents seek to highlight the commercial aspect of the transaction of between the respective allottees and the SPCL. However, the public element in the purpose of the entire project overshadows the monetary transaction. It is absurd to suggest that all public projects are free. Even providing housing, which is a basic and integral component of the right to life guaranteed by the Constitution of India, at reasonable rates to low and middle income groups, is evidently a project in public interest. The SPCL merely acts as an agent of the government, kindly mark this, of the government through the HIDCO to implement the government's task of providing housing at affordable rates to disadvantaged strata of the society. The transaction may be commercially viable from the point of view of SPCL in as much as it gets to retain the sale proceeds, but such ingredient simpliciter cannot confer a commercial hue to the public project. The counter to the privity argument also finds shape in clause 6, which stipulates that as one of the obligations of SPCL, that if the construction of mass housing scheme is not completed and handed over the successful allottees within the said 4 years' time, SPCL shall be liable to compensate suitably HIDCO and allottees of the flats as may be decided upon. Thus, the writ petitioner's right to get timely possession of the flats in the capacity of finalized allottees of the scheme or project, in the alternative suitable compensation from SPCL after the stipulated 4 years flow from the development agreement in such and such itself, despite the individual allottees not being signatories there. The entire authority of SPCL flows from the project and the development agreement as amended till date, which in turn is necessitated by and directed towards providing affordable housing to sustain the lives of citizens, which is obviously a function of the welfare state that India is as per her constitution. The Bengal Shapurji Palonji Development Private Limited is at best and instrumentally in the entire chain of events leading to the writ petition, being a sub-agent of SPCL. Here also, my lord, Sugam is a sub-agent of ADDA. The Shukhabistri project floated by SPCL and the deeds or agreements entered into between the individual allottees and SPCL thus are a consequent to the development agreement between SPCL and HIDCO, which cannot be interpreted in isolation to invoke privity as a bar to the writ. The contract between the allottees and SPCL are not statutory contracts. However, the entire housing project, of which the individual contracts are components, definitely involve a public law element. In as much as the West Bengal Housing Board Act is concerned, the same is not, I'm not troubling a lawsuit with that. Then the next paragraph, the allottees admittedly belong to the lower and middle income group and evidently have much at stake, since a substantial chunk of their savings and income must have gone to the mass housing project in the hope of having homes to call their own. The inordinate delay, even prior to and after the pandemic lockdown apparently occasioned by SPCL and its instrumentalities, at least prima facie indicates serious abuse of resources meant for public housing and translate to increased cost.
Yes.
But thereafter certain decisions are quoted, then the writ petition was held to be maintainable. My lord, I happened to be there in the matter. My lord, the appeal was preferred by my client, WB HIDCO, as well as the developer, but the appeal was withdrawn and the writ petition was withdrawn thereafter on the ground that all the flats were handed over. So my lord, this judgment stays. The appeal was also withdrawn and the writ petition was also withdrawn. Now, my lord, two other judgments, the Supreme Court judgments, which are later in point of time than my learned friend's judgment. Mr. KD, if you could please hand over 2023 to SCC 703. My lord, kindly see paragraph 82 at my lord, page 61 of the report. My lord. Now, this really culls out the entire proposition on contractual matters apropos writ petitions. Now, kindly see paragraph 82. We may call out our conclusions in this, as your lordship got it, my lord?
Yes.
Paragraph 82. in regard to the points which we have framed. 82.1. It is undoubtedly true that the writ jurisdiction is a public law remedy, a matter which lies entirely within a private realm of affairs of public body may not lend itself for being dealt with under the writ jurisdiction of the court. The principle laid down in Bareilly development that in case of non-statutory contracts, the rights are governed only by terms of the contract and decisions which are purported to be followed, including Radhakrishna Agrawal, may not continue to hold good in light of what has been laid down in ABL and as followed in recent judgment in Sudhir Kumar Singh. The mere fact that relief is sought under a contract which is not statutory will not entitle the respondent state in a case by itself to ward off scrutiny of its action or inaction under the contract if the complaining party is able to establish the inaction or action per se arbitrary. An action will lie undoubtedly when the state purports to award any largesse, and undoubtedly this relates to the stage prior to the contract being entered into. This scrutiny no doubt would be undertaken within the nature of the judicial review which has been declared in the decision in Tata Cellular. After the contract is entered into, there can be a variety of circumstances which may provide a cause of action to a party to a contract with the state to seek relief by filing a writ petition. Without intending to be exhaustive, it may include the relief of seeking payment of amounts due to a aggrieved party from the state. The state can indeed be called upon to honor its obligations of making payment unless it be that there is a serious genuine dispute raised relating to the liability of the state to make payment. Such dispute ordinarily would include contention of the aggrieved party. My lord, kindly comes to paragraph 82.9 thereafter, my lord. This is on disputed question of fact. Kindly see 82.10. The reach of Article 14 enables a writ court to deal with arbitrary state action even after a contract is entered into by a state. A wide variety of circumstances can generate causes of action for invoking Article 14. The court's approach in dealing with the same would be guided undoubtedly the overwhelming need to obviate arbitrary state action in cases where the writ remedy provides an effective and fair means of preventing miscarriage of justice arising from palpably unreasonable action by the state. Then kindly sees 82.12. In a case, the state is a party to the contract and a breach of a contract is alleged against the state, a civil action in the appropriate forum is undoubtedly maintainable. But this is not the end of the matter. Kindly mark this. Having regard to the position of the state and its duty to act fairly and to eschew arbitrariness in all its actions, resort to constitutional remedy on the cause of action that the action is arbitrary is permissible. However, it must be made clear that every case involving breach of contract by the state cannot be dressed up and disguised as a case of arbitrary state action, while the concept of an arbitrary action or inaction cannot be cribbed or confined to any immutable mantra and must be laid bare with reference to the facts of each case. It cannot be a mere allegation of breach of contract that would suffice. What must be involved in the case must be action or inaction which must be palpably unreasonable or absolutely irrational and bereft of any principle. Any action which is completely mala fide can hardly be described as fair action and may, depending on the facts, amount to arbitrary action. The question must be posed and answered by the court. To all we intend to lay down is that there is a discretion available to the court to grant relief in appropriate cases. A lodestar that which may illuminate the path of the court would be the dimension of public interest subserved by the court interfering in the matter rather than relegating the matter to alternate forum.
Yes.
Now, my lord, here I base my case on violation of Article 14. My lord, we'll kindly have a look at, my lord, the writ petition once more. Kindly sees similarly circumstance allottees have been registered flats. These are done in 2024. Page 98. I have given the list whichever I have got.
Page
98, my lord, I'm sorry, page 98.
98.
98. Kindly sees the dates of registration. But these have been done in 2022, 2022 to 2024. But they are favored persons, but I do not know what is the reason. And kindly turns to the next page. I'm sorry, page 93. These are the pending registrations list. But I am one of the unfortunate ones.
Page
93. Payments have been made, no ground, no letter issued by ADDA or SUGAM saying that there is non-compliance of anything from my end. Nothing has been given.
Yes.
Now, I write a letter. I have been given an indenture of lease. Kindly see page 50. This draft deed. Kindly see page 50. It is signed by SUGAM. The respondent number 2. Kindly see page 51. Who is executing this as the lessor? The governor of the state of West Bengal. 51.
Yes.
So, my lord, I would be a lessee under the governor. Your lordship would find the names of the writ petition numbers 1 and 2 there at page 51. And bottom of 51, Sugam Park is only the developer. So the entire project is of the state.
Yes.
Your lordship would find the name of Sugam Park in only the capacity as a developer. So, my lord, when this deed is there, my lord, it is executed, it is given to me. I my lord, put my signatures on it, and it is sent to my lord ADDA for my lord registration. That is all which is done. But they do not do that. I've paid the entire consideration. Page 79 is mentioned in the memorandum of consideration. Page 79 of this part of this lease deed. Entire consideration paid. Well, they do not do anything. I write a letter at page 82 calling upon the developer that please execute the deed. I have done everything from my end. That is page 82. Well, they reply, well, at page 90.
Yes.
We have taken note of your contents of a letter such and such. We would like to inform you that all procedures from our end for execution of registration of lease deed in your favor is already complete. The same has already been forwarded to the concerned department of ADDA for execution and registration. However, it is pending with them and the same shall be executed in your favor as soon as it is approved by ADDA. We sincerely regret the delay and hardship caused to you, but we have no other alternative or solution to provide you. Thereafter, we write a letter to ADDA at page 92. No reply to this.
Yes.
And my lord, we have managed to get hold of one lease deed at page 105, which they have executed. Your lordship can see an executed deed that is at page 105. We have got a certified copy of some other my lord allotee. Just as an example, my lord, we have got where your lordship would find who is the lessee. Mine is a unexecuted deed. This is an executed deed. At page 107, my lord will find the name of the lessee. The governor of West Bengal, represented by Special Officer Urban Development.
Yes, sir.
Lordship, firstly, the memorandum of understanding is not on record as on date. So,
what memorandum of understanding?
Between ADDA and Sugam Park, the judgment of Honorable Justice Bhattacharya heavily relies on the understanding that was between the state authority and the developer.
Kindly come to page 90.
Page
90, 90.
My lord.
What remains?
Well, I can answer this. I try to answer these questions and satisfy your lordship regarding the what has happened. But as far as the maintainability point is concerned, my lord, in order to properly appreciate and rely on Justice Bhattacharya's judgment was only based on what was the nature of the project.
No, leave aside the Justice Bhattacharya order. This, who has to execute in the name of the governor?
My lord, certainly.
Correct.
Certainly.
And it is the authority, ADDA is the authority of the state, and your state has telling that yes, all have been ready, but it will be taken time.
So, Lord, it is stated by the private party.
Private party. So what is your contention? If why you are not registering the same?
But I can justify.
If you say that you are not paid the amount, there is a disputed, then okay, the court can say yes, there is a disputed question, and this writ court cannot decide. Once it is stated that he have paid, he has executed the agreement, only the registration is required, and the executor, person who will execute is in the name of the governor. It is the state, ADDA is the state. So how you can now deny that? What is the reason for not registration?
Rashid, I can answer that. I'll try to answer. Is that there is a memorandum of understanding between ADDA and Shugam Park, the private party. As per the memorandum of understanding, it's a joint venture between the parties. ADDA was to give the land and the private party was to make constructions and market it. And we are not no say in what the money they are taking. And the term of the contract was 4 years from 2011 to 2015. 2015, we extended it on their prayer for 2 years. There was a clause in the contract itself that in case of delay, in every month they'll have to pay 5 lakhs. From 2015 to 2017, when the contract was extended, we gave a concession and say for the 2 years you will have to pay only 1.5, but we reserve our right that after 2017 we may impose 5 lakhs per year.
Who?
ADDA on the developer. No, I'm not saying the developer, the joint venture partner. Now, again, when in 2017 it was again extended, they couldn't complete it within time till 2021. In 2020, and we started imposing 5 lakhs per month. They paid up a certain portion of it. And suddenly in 2024, when we were going on imposing the damages, they filed a suit against us, claiming refund of the money that we have already taken from them. In the particular suit, the developer filed an application for bringing for an injunction, a similar injunction, directing us to execute the lease deed. And we say that unless you pay us the money, our portion of the contract was that you will pay us the dues as per the memorandum of understanding, and our portion was only to execute the lease deeds. Unless you make our payment, you do the reciprocal obligations, we are not in a position to execute the lease deeds. That injunction was refused in an ad interim stage. They carried it before the Honorable High Court, and last Monday this was taken up by Justice Bhattacharya. And Justice Bhattacharya was of the opinion, or the division bench presided, that we took a preliminary objection in that matter also. It is not a non-commercial but a commercial matter. It was held that yes, it's a commercial matter to go before the commercial court. And also the injunction was refused on the ground that at this moment, if the injunction is granted, it will actually be granting the ultimate relief in the suit. This is where the matter stands as on date.
What is the relief in the suit?
Relief is the suit was they had claimed for money.
Who?
The private partner against us. They had been going on paying the delay, the.
Okay, how soon you file the affidavit?
As your lordship pleases.
Disclose all these things.
May I only indicate one thing?
Mr.
But this is a crossfire. I am caught in the crossfire between the developer and the
respondent number 2 has initiated a suit for recovery of the money from the estate. So that might be there is a dispute.
From whatever I understand from my learned friend submission, that is with regard to penalty.
Correct. Whatever it may be.
That they may get from the developer, from their partner. But I am an allotee. But I am an allotee. My allotments are being stuck. So they can file a suit, they can haul them up, they can get whatever money they can get from them. But when I have not committed any breach of my contract. So here
number 1, raise for time to file affidavit. Let the affidavit file within a week.
To 2 weeks.
Within 2 weeks, you will file affidavit. Let the respondents file affidavit in opposition within 2 weeks. Reply, if any, there to be filed within a week thereafter. This is the matter on 9th of December 2020.
Grateful.
Oh, my lord, rises is something very urgent, my lord. I have to bring to my lord's notice. My lord, this relates to an original side suit where my lord was sitting in court number 38 2 weeks ago. My lord was hearing an application execution without a drawn up decree. An order was dictated in open court, but before it was signed and uploaded, my lord had mentioned that I want to deal that the Bombay judgment, which now my lord had directed them not to upload that order. This
Also
order,
after the order, I kept one, but he
Yes.
failed to mention the matter
No, no.
before this court. 3 days, this court waited. He has mentioned 2 times.
And I had pointed out what was actually
pointed
the
out thereafter
submission
the
of the
signing order.
judgment.
my lord,
letter.
my lord,
Yes,
What was the
yes,
submission?
I was not
Honorable
notified.
Justice
I was
Roy.
not given any notice, my lord.
But
Sir,
there is no relation between the department
it was
and
your
the decree holder.
See, it was the last day when the
Yes.
determination
Matter
was
appeared on
changed.
Tuesday before the court.
It was the last day when the determination was changed. You
Yes,
came
my
in the last hours and you're telling that. So
Yes.
I will not sign the order and inform that. But you have not come on Monday, Tuesday, or not come before
My lord,
this
the
court
matter
to mention-
appeared on Tuesday before.
Maybe the matter appeared before that court.
Yes.
They have mentioned
And
you made some submissions.
It is
but
already-
you
it was-
have not come. You have not
তুই
come before this court.
এইভাবে কি করে
You
submission হবে?
you have not come before this court. So you wanted to argue the matter. So that's why you have not come. Then I signed the judgment and this
My
was
lord,
uploaded.
may I say this? How I understood the situation. My lord fixed the matter on Tuesday to be mentioned. Monday the bench changed. Tuesday the matter appeared before Justice Anirudh Roy. Where, my lord, there was an order passed. The order has not been uploaded. My lord, I understood the matter will now be taken up by that court.
That's why after the order you could have been mentioned before this court. You have made a submission. Kindly see your submission is recorded.
Yes.
I have gone through. Your submission is recorded. You have not came before this court. You have submitted.
And there was no such submission like this.
You have made some other submission before the court, commercial court. Kindly see your
But I
submission.
said the order has not been uploaded.
I don't know. How if it is not uploaded, how it is come?
My lord,
Then you have not come. Then I found
I know
this
that
court
it-
find that you are not
I am
interested. I
surprised that the matter was mentioned by my lord without notice to me after.
No,
the
it
bench
is
was
uploaded. What can be done?
No,
It is
difficult to
between
be
the
serving me a notice of contempt. But they have served me a notice of contempt. My account has
No, that's why again I given
Because-
chance. Once they have
They did
mentioned,
not notify me before
I don't know. They
Yes.
have mentioned the matter.
without notice to me.
They have mentioned the matter. I told no. He have kept it. Subsequently, they have brought the order stating that in the website order passed. Once it is mentioned in the website order passed, then I have to sign the order. What can be done? You persons are taking time and you are not coming to the court. What can be done? The court cannot invite you. What can be done?
This matter, there was an order that it was fixed at 2 p.m.
Today?
Yes. But since your lordship is taking up all these appellate side matters and
I think today the ordinance and matter will be taken from 3:30, but there is. So I will fix another
Yes,
date
Madam, let
for
another-
what? Hearing or witness?
Yes, Madam, that is that power of attorney matter.
Okay, that one.
That
Yes, it
one.
is listed today.
Yes, yes.
So I will fix.
Yes.
But new one.
New application.
No, it is this. That has been
we have to see
especially
whether-
assigned with regard to the only this.
This GA1. This is 10 and 11. Item number 10 and
21st, I don't think. 21st is a Friday. Acha.
Is your lordship taking up at 3:30 every day?
Friday है ना Friday क्या होता है लेने के 21st is Friday.
Friday.
You take risk, then I will fix.
Again, it will be a 3:30.
I don't know.
We have given the vesting date on that day.
Okay.
As you
Now
know.
before this court, that whether it is assigned.
But this matter is assigned.
The entire suit is assigned. Then that application will
So
appear.
suit is assigned here.
Yes.
Yes,
Suit
yes.
assigned है क्या? Okay, let it come on 21st then.
Very well.
21st.
And in case it is 3:30, then your lordship will be taking up at 3 o'clock, original side, my lord. Otherwise, by 3:30, the day of original side will be lost. That your lordship will consider later, but.
My order, you do one thing, come at 3:30 before rising, I will pass an
Yes,
order.
yes.
Because my officer,
Yes,
original side officers are not here.
Yes, yes, we shall come.
Come at 3:30 before rising. You
Yes.
Item number 13. But I'm for the petition, my lord, the state.
My lord, the state. My lord, probably this is an application for restoration. We do not stand in the way of the restoration, though a formal objection may be recorded.
My lord, the matter was dismissed today, my lord. So we have.
Today dismissed, I have not signed the order. CM mentioned that you have not signed the order.
If-
What
if-
about the merit of the matter?
My lord, Mr. Shane Gupta is in this matter. If the matter can be taken up on Monday,
That is the problem. See that the matter is ready. That's why I.
my lord, he's engaged in another court.
Can we fix at 3 p.m., my lord? Then
My lord, today it would be a little difficult. If my lord kindly fixes the matter on Monday.
Item number 13. Not to pass, not to take. Record. As per the prayer made by the counsel for the respondent, the case is adjourned. Let the matter appear on 19th under the same heading.
kindly, my lord, the matter.
19th under the same heading.
But if the matter is the same position in the list, my lord.
Yes.
Wait, my lord.
Monday.
19th. 19th, sir.
19,
My
19.
lord, 19, my lord.
Deeply obliged, my lord.
Yes, call the list.
Item 19.
I'm for the petitioner, my lord.
Yes.
I'm appearing on behalf of Advocate Prunankar Vishwas. He is suffering from viral fever. Due to his illness, I'm praying for 2 weeks of accommodation.
Suffering from virus fever after the illness.
Due to his illness, I am praying for 2 weeks of accommodation.
Consider the case and dispose the representation. What is the representation? Where is the representation? You not having brief.
No, my lord.
You could have been. These are the small matters. You juniors. How many years you are having practice?
My lord, this year I passed out.
As per the prayer made by the counsel for the petitioner, case is adjourned. Let the matter appear on 20 and at the same heading. 20.
My lord.
On behalf of respondent number 8, my lord, I'm praying for a short passover.
But
I'm not the leading counsel, my lord.
the matter.
That is fake certificate issued to some political leaders, like previous one. In this case, my lord, what happened? Petitioner filed a public interest litigation. The division bench recently held that as he availed the remedy, therefore this is dismissed, but the SDO will act in accordance with the law. But SDO what did he never issued any notice to the complainant, and he's in the penultimate paras held that no original document is available. Even then he passed an order.
Okay.
Another, my lord, note Madhuri Pali's case, that there are the guidelines given by the Supreme Court. Actually, 1994 Act, they are amended in 2007 again.
My lord, for the respondent number 9, my lord, I laid by Mr. Rudolph Shankar Chattopadhyay.
When will you available? Your seniors?
My lord, I'm praying for 1 week accommodation, my lord.
1 week.
Well, only 820, 90 and 80.
18th, 19th?
No, 19th, there is a fixed matter.
Okay, 20.
20. Grateful, my lord.
As per the prayer made by the council for the respondents, let the matter appear on 20. Affidavit of service filed by the petitioner be kept.
Actually, earlier order, like the fake certificate, what happened? After Madhuri Pali's case, Supreme Court gave guidelines, and it was given to all state government, modified the rule that this committee should be constituted to identify, and vigilance commission should be there. But 94 amendment, after that 2007 amendment is there, but the that has not been notified. Committee has been constituted in the act, but not notified. Therefore, the SDO is the authority.
Okay. We are on 20.
Grateful, my lord. My lord, I am for the petition.
Ready?
My lord, I'm for the distribution company. My lord, before we start, my lord, on the last occasion, the order was published. My name came in, my lord, somebody else's name has been appearing.
What is your name?
Shomuji Chakraborty, but
So how this name has come? Mr. Bandyopadhyay name has come. Yes, what is the matter about, madam?
Electric meter.
New electric meter. Why?
The private respondent presses for the new electric meter, but when he is also the party and he is in the development agreement part. Now, how can he resist the new meter?
Yes, you are appearing.
I'm for the distribution company.
Your Honor, I'm appearing on behalf of the private respondent number 5. Your Honor, in this case, there's a arbitration case going on between the developer and the respondent number 5 at Barashat. And there are certain other cases pending as well, for which, Your Lordship, I would like to file.
Correct. That's correct. Okay, whatever the case is pending. The electricity cannot be denied, but that is subject to outcome of the proceedings. What is the proceedings? Eviction.
Your Lordship, there's a cancellation of development agreement.
If the development agreement is, but they are in occupation. Petition is an occupation of the premises in question.
That is also in question, Your Lordship, because the project was not completed and there's.
So then I will call for the report. Submit the report.
It's under construction, my lord. They have
Okay,
fixed for
you do
construction
one
power.
thing. I am fixing next week. You submit the report whether.
That we can do anything with the flat.
Correct. You are in occupation or not? You are in occupation or not?
Yes.
The flat you are occupied or not?
Yes,
you are occupied? Under construction. So why the electricity? For renovation? For completion of the construction? Once the proceeding is pending, how you can sell? I don't know what is the proceeding.
This is sought for construction power, my lord. In that occasion, we tried to provide him 3 times, but objection every time.
Who has the objection?
The private vendor.
Why?
Your Lordship, in the writ petition, subject to my correction, Your Lordship, because I was not properly briefed. My senior is representing, but she's not well. So I'm.
Who is your senior?
Piyalipal Roy. The main construction was supposed to start in the year 2014, However, there was dispute. There is there's a
Who
DR.
are you? You are the developer.
No, I'm the private respondent. Number 5, I'm the landowner.
You are the owner.
Right, Your Lordship.
And you have given the property for the development.
Yes, Your Lordship.
Share of the developer has sold to the third party.
The first agreement that they have spoken about in their petition was executed between the developer and my father, who's now deceased, and they have also executed a new development agreement and power with me as well in 2017. However, there is a DRT case pending with LIC.
Okay, you do one thing. Both file short affidavit. How soon you will file affidavit?
2 weeks time, Your Lordship. Your Lordship, the reason being that she's bedridden. I'm just trying to make sure that I do not. My senior, she's the one appearing.
Okay, file 2 weeks, 1 week. Let the file affidavit.
Kindly be recorded that we have no objection.
Let the file affidavit. Or affidavit by way of report. Report by way of affidavit, whatever it may be.
I'll file a report on through affidavit.
The counsel for the respondents wait for time to file affidavit. The officer and the WB SCDCL.
Yes, my lord.
SCDCL is directed to file a report by way of affidavit. The private respondent directed to file affidavit in opposition within 2 weeks. Reply for the petitions given liberty to take exception to the report, if any, within a week, and reply, if any, to the affidavit in opposition of private respondent within a week. List the matter on 2nd December under the heading adjourn motion. The full list of counsel for the WBSCDCL submitted on 7/11/2025. He has appeared in the matter, but name of another advocate, Mr. Kanak Kiran Bandopadhyay, is recorded. Accordingly, in the order dated 7/11/2025, name of so and so.
Also, one thing, my lord, on the last occasion, it was taken up on 3rd, but when it came in, it came on 7th, my lord.
7 January, 7 November.
But the matter was taken up on 3rd.
Don't know, but 7 is 7.
Okay. Grateful, my lord.
For the private respondent.
Right for the electricity. Authority, Lord. That is that starting from the page 14. Lord, the authority has already some that is at page 18 of my petition. This required to be deposited by the petitioner.
Page 18.
Page 18.
Yes.
Lord, the petitioner applied for the electricity and the system got the payment made by the petitioner. That is 2014 Act.
Correct.
Yes, but my lord, the said the authorities have not received the said amount as because the landlord has not issued the no objection.
Issue no objection with regard to?
As because the petitioner is a tenant and there is a dispute between the landlord and tenant, and as because the objection has not been issued, the connection, electricity connection is being withheld. And there is a judicial judgment, that is judicial judgment of our High Court, and my lord also passed the order sitting over the traffic bench. While this judgment was disposed of following the case Rama Goda deceased, while the representative to his legal representatives versus M. Varadappa Naidu, reported in EIR 2004. The Supreme Court 44609. It is clear that so far the Indian law is concerned, the person in peaceful position is entitled to retain the position, and in order to protect that position, he may courts keep out a trespasser. Here that even an occupier is entitled to get the electricity, and on the basis of that, in the paragraph 13 of the distribution judgment, judgment of our High Court, that when the rule 2006 was introduced, the legislature had in their mind appropriate concept of settled possession that culpable with independent against state of dispossession even at instance.
What is the name of the case?
This is Ovimannu Mojumdar.
In the circuit bench, full bench.
Circuit bench, full bench.
See the appearance. See the appearance.
Lordship has appeared in this matter, my lord, as a appearing in the I have read the judgment. So, and my lord knows this judgment, so I am not reiterate this. And my lord, following this judgment, your lordship in the sitting before the court fair bench, my lord, passed the similar order that the occupant in possession is entitled for the electricity.
Unless he is evicted. Unless you are evicted in accordance with law.
Still today, my lord, I am in possession of the judgment of which I am right.
Yes, which authority you are appearing?
My lord.
What is the what is the contention?
My lord, he has made the application online. My lord, your lordship knows, my lord, the procedure is, my lord, after making the online application, automatically, my lord, quotation will be raised, and my lord, he has already paid it. But my lord, the process is, my lord, he has to deposit the hard copy of the filled up form, duly filled up form, along with, my lord, necessary documents. My lord, till today, my lord, he has not deposited or submitted any document. First point, and my lord, the second is, my lord, there is a dispute because there was an existing connection in the name of the landlord. One of the landlord, my lord, requested for disconnection, deposited the requisite fees, and my lord, we have duly disconnected it. So, my lord,
So now the tenant is applied for.
Tenant,
you can give the.
Lord, no, my lord, he has to, my lord, follow the procedure. He has to submit
in accordance with law.
Yes.
The only things, my lord, any document show as to whether he is tenant or not.
Not required, sir.
But apart from
For
that,
the electricity, this is
I
not the
do
civil
appreciate-
code to decide the title. For the
No question of
electricity,
title.
electricity is the essential service. If the authority found that he is in occupation of the premises, legally, illegally, whatever it is, he is entitled for the electricity. The electricity can be disconnected unless he has been evicted from the due process of law. This is the law as on today.
I do appreciate. My lord, only one thing for a moment. The person forcefully entered into the room and stated that I am the tenant. But any piece of document placed people or ships.
You take recourse of the civil code.
Well, that is
evict him.
That process is still going on.
Yes, that's what I'm telling.
That should be indicated.
I will indicate.
Yes, ma'am.
That order will indicate.
Yes, that should be indicated.
When you applied for, where is your application?
At page 18 of
Page 18 is the amount which the authorities have informed you. Where is your application? On
the application is not at all filled up. Kindly see, it is not at all filled
your application.
By whatsoever taking that, they are trying to, my lord, establish the tenant. There is no question of tenants.
That I will record. That will record the full bench also.
Yes, I do appreciate.
Merely grant of electricity connection or water connection will not create the title.
Yes, not creating right of tenants.
Not create the title. What the right?
The
Then
title means another
he
title.
He cannot ask the possession of the property only on the basis of the electricity provided.
Yes,
that is the
that should be indicated.
When I was appeared that side which they are appearing, I was the same submission, but that has not been accepted.
that is long back.
2011.
Yes, now 2025.
Where is your application? Online application? Not.
Annex P2, my lord.
P?
Page 14. Page 14 it starts.
page 14.
Record.
My lord, he has applied only.
Already
he has not yet deposited the quotation money.
Correct. The petitioner.
Lord, liberty may be given to deposit, Lord, because they are denying the deposition of
The grievance of the petitioner in the present writ application that the petitioner has applied for grant of electric connection, for grant of electric connection, and on receipt of the application, comma, the WBSCDCL has notified the payment of rupees 2049
quotation
49 being the security deposit of the electric connection. The petitioner, when approached the authority for deposit of the said amount, comma, the petitioner found that the authority found that the landowner of the property in question has raised objection, and as such the amount, the payment.
Well, I deny this because
I am recording, and as such the authority have not accepted the said amount. Counsel for the petition. The petition is an occupation without
online payment.
and the private respondent cannot object for grant of electricity. The standard advocate appearing for the learned counsel for the petition has relied upon the judgment in the case of Abhimanyu Majumdar versus Superintending Engineer, reported in 2011, Volume 2, CHN, within bracket Calcutta, 768, and submits that the special bench of this court has categorically held that the electricity cannot be denied even in the illegal occupier of the premises, and thus premises, full stop. The petitioner has further relied upon the judgment passed by this court sitting in circuit bench at Port Blair in WPA number 216 of 2025, dated July 11, 2025, and submits that in the said case also, this court has categorically held that the illegal occupier is also entitled to get the electricity connection unless he is evicted in due process of law. By referring the said judgment, the counsel for the petition prays for direction upon the WBSCDCL for providing electric. Per contra, an advocate appearing for the WBSCDCL submit that the though the authority have notified the amount of rupees 2,049 being the security deposit for providing electric connection, but the petitioner has not deposited the same. If the petitioner will deposit the same, the authority will take appropriate steps in accordance with law for providing electric connection unless the petitioner comply all the provisions for providing electric connection. Learned counsel appearing for the private respondent submits that the petitioner has illegally entered into the premises of the petitioner and has illegally occupied the premises in question, and as such, the private respondent has raised an objection for grant of electricity. He further submits that he initiated the case for eviction.
Steps already taken.
He has already taken steps for eviction of the petitioner from the said premises. At the learned counsel for the respective parties, this court finds that the petitioner has already applied for grant of electric connection, and
that's what you indicated my submission by virtue of that the electric connection, the right cannot be cleared.
I will record. Has already this court finds the petitioner already applied for grant of electric connection, and the WBSCDCL has notified the amount of rupees 2049 being the security deposit for providing electric connection. But the petitioner has not deposited on the ground that the private respondent has resisted for the same. This court finds that there is no dispute that the petitioner is in occupation of the premises in question. It is also found that the petitioner has applied for grant of electric connection and authorities has notified the amount being the security deposit for providing the electricity connection. In view of the above, the WPSCDCL, the respondent number 2 is directed to provide the electric connection in the premises.
Kindly make it 3. 3 is the station manager, the concerned person.
3 is directed to provide the electric connection in the premises of the petitioner on compliance of all formalities. Within a period of 4 weeks. Within 4 weeks from the date of receipt of compliance of all formalities by the petitioner. It is however made clear that it is the allegation of the private respondent that the petitioner is in illegal. The private respondent is the owner of the property in question, and the petitioner is in illegal occupation of the premises in question. It is made clear that the providing the electricity will not create any right, title, interest of the petitioner in the premises in question. By allowing for grant of electricity electricity, the private respondent is not restrained from taking appropriate steps for eviction of the petitioner in accordance with law. Great, WP is disposed of.
चला
Next.
एक कागज ने but I am for the WBACTC.
I want to withdraw this. I'm trying to liberty to file a case.
Why?
Well, there is nothing. There is nothing in the petition there. So
why liberty?
It an in.
Because all the documents have not been annexed. I don't know.
The counsel for the petition submitted the counsel for the petition prays for withdrawal of the writ application, liberty to file a fresh. Accordingly, WPA number 2403/2025 is dismissed as withdrawn, liberty to file a fresh.
Grateful to me.
और क्या affidavit है सर?
Our affidavit is good.
May I please?
Daniel advocate,
Hey.
Rahman, Daniel advocate, Hayo Rahman, on behalf of the petitioner, is till today.
May I say one thing subject to my learned friend? This is a case of a pilferage. As usual order, your lordship can give a direction of filing affidavit subject to it, because I want to put it on records, all the documents. He has stated.
Not today. Not today, sir.
Huh?
Not today, next day.
Not today. Not today.
I am not on that. Because it will be passed, because it will be put it on record.
No, then he will be in problem.
No, I am not saying.
Yes, next.
25.
I can take WBACDC.
My lord, I am appearing for the petitioner in this matter.
Yes.
Lordship. Lordship, this case is that the petitioner purchased a particular property in 2010. And at that point of time, there was an existing meter, electricity meter, in the name of the previous owner. And thereafter, in 2013, the petitioner got a new electricity connection in his name. And subsequently, my lord, after some years, that electricity meter belonging to the previous owner was stopped being used by the petitioner. However, the respondent authority would or used to send nominal charges like the energy, the meter rent for some period thereafter. And finally, in 2017, that meter was completely stopped being used, with a reading recorded and reflected on the meter itself. However, Lordship, recently the WBACDCL has served a notice upon the petitioner claiming an absurd amount relating to that meter and alleging a nexus with the previous owner. That is my grievance, my lord. And there is one other point. Previously, the WBACDCL served a notice claiming around 80,000, and after the petitioner sent a representation, it became 18,000 with the late payment surcharge. That is my grievance, my lord. There is no logic on that.
Where is the impugn order? Page number?
Yes, my lord. Page number, my lord, 29. There is one. Page number 29 and 38. These are the two notices, my lord.
The final notice is at page 38, Lordship.
Yes.
38.
It suddenly became a less amount.
LPC 9,000.
LPC means late payment surcharge, Lordship.
Okay. And outstanding 7,900.
7,938.
Yes. So what is
My lord,
the
kindly, yes, my lord, kindly consider page 29, annex P4, annexure P4.
Yes.
That was the earlier notice,
Hmm.
and after my representation, probably they came down to 18,000 from 80,000.
18? Yes. So what do you want now?
But I want them to be quashed by your lordship. There is no due as such, my lord.
My admitted position.
If you will not pay the
Yes.
the due, how you will get the new electric connection?
But
My not questionable
lord-
connection. He is getting the electric connection. He has got the existing meter. What happened, your lordship? Admitted position is that he has acquired the property or purchased the property in the year 2010. There was an existing meter in the name of one lordship.
Vandana Singh.
Vandana Singh. Now enjoyed that electricity. Subsequently, the petitioner took the meter in the year 2013.
When he purchased?
He purchased 2010.
3 years.
3 years he enjoyed that electricity. Subsequently, he took the new meter and enjoyed the electricity, and he never surrendered that meter, that which was lying previously prior to taking that new meter. And he enjoyed that meter. And he
You
found
allowed
that
it?
there is a meter reading is there, then we have said that this is the meter reading. You pay that amount unless you
Meter
pay
reading from which year to which year?
Yes, meter reading your lordship will find that is from that I can ascertain before, because I have got the, I am carrying the bill.
File report?
I will file the report subject to your lordship kind of
File short report by way of an affidavit disclosing all this.
lordship.
Serve the copy to the other side.
Lordship.
And if you want to file the
exception to this report to the other.
Yes.
Grateful to your lordship.
How soon you will file?
At least 10 days time, lordships. But I'm praying for that, lordship. Lordship, can it be 2 weeks subject to lordship?
Respondents are
But
direct.
10 days thereafter, but some more days will be needed for me to file the exception.
Director to file a report by way of an affidavit within a period of 2 weeks from date. After serving the copy to the London Council for the petitioner, the petitioner is at liberty to take exception, if any, to the report within a period of a week thereafter. Please the matter. On 10th of December 2025.
I'm deeply obliged.
Grateful to you.
I'm for the state unit.
Petitioner before his lordship, my lord, she runs up to the owner of a heavy goods vehicle.
She or he? She.
Her business is running that vehicle and transporting goods. So, my lord, what has happened on 9th, from 9th October to 14th October, my lord, he engaged one driver with her vehicle, my lord, for transportation of modern material from Kharagpur to, my lord, from Gagrasol, my lord, to Kharagpur workshop. On 12th, my lord, her vehicle was apprehended. Her vehicle was apprehended by respondent number 8 and other 15 other my lord unknown people who demanded around 1 lakh rupees from the driver. Now, my lord, I would like to bring your kind attention to the fact, my lord, that she has already paid, she had all the requisite documents. She already paid the requisite tax that has to be paid for this transfer. The vehicle provided all the documents to the respondent number 8. Subsequently, she established contact with the owner. Owner, my lord, being the petitioner before your lordship, had a talk with the respondent number 8 and respondent number 10, which is, my lord, the additional district magistrate. And, my lord, the BLLRO officer. But however, my lord, despite submitting all the documents, they illegally apprehended that vehicle, and my lord, they stationed that vehicle at the respondent number 13, which is the private respondent before your lordship, who is the owner of HON'BLE. So they have kept it stationed there from 12th October. Till date, it is stationed there. I have already lodged a complaint, my lord, which my lord shall find in page number 25. Before the respondent number 8, I have reiterated my circumstances to the owner of the vehicle on 14th October. Till date, my lord, I have received neither a reply. My vehicle has been arbitrarily and illegally detained, my lord. Now,
Why your vehicle was apprehended?
my lord, illegally, my lord, I have not been stated any reason behind the same.
Your lordship, if I
My lord, this is
Yes, yes, yes.
my lord. I have also, my lord, I have an Indian Union vehicle registration certificate also, my lord. My lord shall find it in page number 20. And I've also paid the requisite tax that has to be paid, my lord. I had all the documents, my driver had all the documents, he handed them over. Despite the same, my lord, they apprehended my vehicle arbitrarily. Now, my lord, being the petitioner before your lordship, I'm running pillar to post. My complaint is not being considered.
Yes. Yes, madam. What is
Your
the
lordship, inspection has been done on 12/10/2025, where the driver of the petitioner has failed to submit any valid challan or any other cogent documents which says that they are transporting a lawful minerals. Now,
Yes.
now, your lordship, on 14/10, the petitioner has submitted a written objection, but there also they don't have produced any.
What are the materials in the vehicle?
Your lordship, it was Moram.
Moram. Yes.
Now, they have not furnished any supporting documents. Accordingly, a hearing was given on 29/10/2025. Notice was served. Your lordship, kindly come to page 10 of my report. On the same date of hearing, they were absent. They were not present on that day. Now, as an order has already been passed by ADM, their remedy lies before
Order.
your lordship in page 10 of my report.
Yes. So what after this order, what has happened? Nothing.
Your lordship, now they have to file an appeal.
You
if
got
they are
the
agreed,
order?
your lordship.
My lord, that is the surprising thing in the incentive petition. If it is a case of the, my lord, state respondent, that I failed or my driver or helper failed to produce that e-challan, what not prompted them to issue me a notice, my lord? They didn't serve me any.
Yes, your lordship, we have.
I am coming. My lord, kindly take note of the date when I filed the writ petition. The day I filed the writ petition.
What is the date of the filing of the writ application?
My lord, I filed the writ petition, my lord, on my lord 24th of September.
24th September. When the
Cross-checking it.
24th of October.
October.
24th October.
October.
And then
On 24th October at around 4 p.m. I got the number and served to the GP office.
What number?
The read number. On 7 o'clock, my lord.
When the vehicle was apprehended.
12:10.
My lord, on 7 o'clock at around on the same day, the officials of ADM went to my residence and my lord tried to serve me a notice. When I disclosed them, what is the reason? What is the notice? Without disclosing anything, they forced me to put my signature. My client called me. I tell without official anything, don't put signature in anywhere.
When?
My lord, on the day of filing, when I got the number, my lord, probably on 26th October at around 7 o'clock. I can come up with a supplementary affidavit putting those things in record. My case is that, my lord, the challan issued by the state respondent, not any, my lord, any other authority. They don't have those documents with me at the time of, my lord, stopping my vehicle.
Where was your driver when the vehicle was apprehended?
My lord, it was apprehended within their jurisdiction, my lord, near Chourongi Mode, the place called Chourongi Mode, falls under the same ADM. The issuing authority is the same authority. What prompted them to stop my vehicle, my lord? If I don't have at all any document.
That is the case. They have stopped. That is the case of the respondents. Your vehicle was stopped. Your vehicle was carrying the illegal moram without the challan.
My lord, that is I am saying illegal moram. Then my lord, that documents who have issued that. My lord, page 24. Valid period from 9/10/2025 to 14/10/2025. My vehicle was stopped on 12/10/2025.
Correct.
My lord, permission for carrying 12,000.
So you do one thing. Have you got the order?
No, my lord, no.
You
Sir, will serve.
saw the report?
My lord, may I come back then?
Yes. What steps you want to take? You take this. Kaniti, there is a order. Page 11, 10, 11, 12. Page 11, 10, 11, 12. There is an order.
There is no penny. That order is passed without, my lord, hearing.
That's why you have to take this
Yes,
step.
because you have.
My lord, let me come, my lord, before your lordship seeing that thing, my lord, on Monday I am coming, my lord, because the surprising thing is they give me a license to carry out moram. Now
They were not possessing that at the time of
for the
inspection,
state
Your
respondent.
Lordship.
my lord, kindly appoint
Has
a
filed that
advocate commissioner, go and inspect where my vehicle
as the
is.
report after serving the copy to the London Council for the petitioner. The Council for the petitioner press for a time to go through the report.
Affidavit of service.
Go through the report according to the third John. Full stop. Go to the report. Full stop. The petitioner is given liberty to take exception of the report, if any, by 19th of November 2025, after serving the copy to the London Council for the respondent, state respondent. This is the matter on 20 November 2025.
In the meantime, my vehicle be released, my lord.
Come on, take the report because there is an order. That's why. Otherwise, I could have passed an order.
I will execute the security.
Come on that day. Come on there. I will dispose of. I will. 20. Otherwise, I could have passed an order. But there is an order of the authority.
My lord, I have an instruction of such still in the vehicle.
Okay, come on that.
Item 27, I am for the petitioner.
My lord, I am for the state. My lord.
I am for the respondent number 6. 6.
Lordship. So he has a one flat, Lordship, and that was occupied by the private respondent.
Flat.
Yes, Lordship.
Yes.
And thereafter, the petitioner was file a petition before the lower court, learned court below, under section 163, clause 2 of the BNSS, and there was a specific directions given to the police authority, Lordship, that the opposite party is directed to not restrain to the petitioner to enter his house. So that was not complied by the opposite party, Lordship.
Which matter
Yes, Lordship.
Who has passed an order?
Executive magistrate.
And thereafter, Lordship, I am file a written complaint before the police authority, but till date,
police authority has not received, not complied this complaint.
What you
and
prayed for
not
here?
taken any action, Lordship.
So what you prayed here?
Lordship, I am just praying that the kindly enter my kindly one second, Lordship.
Page 22
Direct-
is prayer.
Kindly direct to the police authority to take a step to enter my house.
Police in action go by side court, not
No,
this
no,
court.
Lordship,
My lord, may I submit one thing, my lord? My lord, what
This court is
happened?
not a determination of the
Lordship,
No. They are not alleging that, my lord.
and
The
also
petitioner is the father-in-law of respondent number 6. The respondent number 6 is daughter-in-law who is residing in the premises. The father-in-law is residing at Pune. Permanently, she is residing at Pune. There is a dispute between the daughter-in-law and his son, and his son has put the respondent number 6 in the residence of the respondent petitioner number 1. My lord, this is the fact. My lord, in that score, my lord, which he is referring an order of executive magistrate.
How this writ is maintainable? without
Right,
this
my lord,
court?
correct.
Lordship, I am praying just
The
the
dispute between the
effect
parties.
of the executive magistrate order, Lordship.
Yes.
Kindly see, Lordship, page number, Lordship,
Kindly come to
104
your
of the Annex
prayer.
P6, Lordship.
Kindly come to your prayer.
Yes.
My lord,
Page
kindly come to prayer.
Page 22.
Last portion.
The police station so and so and reside there peacefully without hindrance and obstruction from the corner outside. So you go to the civil court, obtain an interim order. How?
My lord, on the other hand, they are
I
trying to
also have
evict
a-
me.
I also have an order, Lordship. I have annexed this order, Lordship. Kindly see page number 104 of this petition, Lordship. Once more. May I read this?
Yes. The executive magistrate.
Yes.
Lordship.
You file an application before the executive magistrate.
Yes,
Where
Lordship.
is the order?
I have annexed the all.
My lord, 104.
104 is there. 104.
Yes, this is the order, Lordship, and 105 is the my application, Lordship. And there is a specific direction. The OC
My lord,
or
kindly,
IC is directed to
kindly
ensure
read, my
that
lord,
the OC
paragraph
should not
6.
disturb the entire of the petitioner over the shoot plot, Lordship.
Okay. So go approach the magistrate. The order has not been complied with.
Lordship, I have get a order, Lordship, from the executive magistrate
Correct.
that was not complied by the respondent authority, Lordship.
So go before the magistrate, file an application. They are not complying with the. They will take the police action. How the writ court? If you want the police action, this court is not having the determination.
My lord, by filing this writ,
What is your prayer?
Lordship, I apologize, Lordship. In this matter, my senior he is appointed, Lordship. So, Lordship, kindly adjourn
From the
this
prayer,
matter.
after going through the prayer in the writ application, this court find that this court is not having the determination according to the
Lordship.
My lord, this
WPA
is
number so released from the list of this case.
This is not a
Released from the list of this. The petitioner's liberty to take appropriate step before the appropriate court of law.
Kindly
Yes,
consider-
call the other matter.
I have not paid the Lordship.
Call the other matter.
Lordship.
Lord, I appear for the passport authority.
The petitioner.
Lord, actually, we need some time, at least 10 days time, because the deputy passport officers called me
What is the prayer?
for the
Passport?
instruction, for, yes,
For
passport,
issuance of
instruction. For the
passport
instruction.
renewal. I was issued with a passport. It expired on 24/6. Thereafter, a case was filed against me. The Honorable High Court stayed unquashing, stayed all proceedings. Thereafter, I approached this Honorable Court, where this Honorable Court, my lord, directed to apply in terms of law. I applied in terms of GSR, my lord. I obtained permission from the court below so that I can be issued passport and I can depart from India. Both orders are there. Now, thereafter, I made a representation before the passport authority to issue a fresh passport because it had expired on 24th of June 2024.
Okay, let me take
Lord,
instruction.
Yes, because he has not annexed the renewal application. We need instruction whether any other criminal case is pending. So, 10 days time is required.
Then at ASG, appearing for the Union of India.
Passport authority respondents.
Authority respondent.
Union of India and passport authorities.
In respond number 1 and 2. Respondent, accept respond number 4 and press for 10 days time to take instruction. According case is adjourned, let the matter appear on 26th November.
The only thing I find
Number 2.
in the array of respondents. Array of respondents.
Except the 4. Except 4. Except 4.
1, 2, and
1, 2, and 3.
1, 2, and 3.
Yes.
From the array of respondents, I find
Station house officer.
Passport Authority, Union of India.
Yes.
দেখো না আন্দাজে বকো কেন?
What?
না দেখে যাতা বকো।
Number 2.
Yes, next.
কবে বললো এটা? কত তারিখে বললো?
Lordship, I appear for the
My lord,
petitioner.
only one thing, my lord. Instead of 26, can it be on 27th?
27. Record the 27.
Lordship, I appear for the petitioner in the matter, sir.
29?
Yes, 29, I appear for the petitioner. Lordship, the writ petition is essentially for release of admitted dues. Lordship, I am a contractor who was given a tender. I was awarded a tender. My work has completed. Now, thereafter, Lordship, the tendering authority is the additional executive officer. The only reason that they are withholding my admitted amount, which they have admitted, I'll show the documents, is by saying that the principal, which is the respondent number 4, they were the requiring body and they have not released the amounts to the tendering authority.
Requiring body means?
Lordship, so
what is the tender?
The tender.
What is the work?
Lordship, let me just, the work is for constructing a 2-storied girls' hostel building in that college. So the information
Education
that we
department does not release the payment.
Lordship, and the tendering authority says that until we don't get money from them, they cannot give it to us. This is the short substance in the writ petition, my lords. May I just show you, lords, the
First, what is your stand?
So, Lordship, I am appealing for the state respondent. State is not involved here. It is a tender floated by the concerned Zilla Parishad.
Who is the person? Zilla Parishad?
Lordship, the Zilla Parishad and the principal, the respondent number 4. 2 and 4 would be the.
2 and 4. Who is appearing for? You are appearing
for the Bankura Jila Parishad.
Jila Parishad.
Mr. Shomi Ganguly is appearing for Bankura Jila Parishad. His father recently passed away. He is not available right now. I am praying for not today.
Not today?
Yes.
Tomorrow he will be available?
Yes. Next week he will be available. Yes.
You are appearing for?
I am appearing with college, my lord. Respondent number 4.
Have you
College.
released the amount?
My lord?
Why you not release the amount?
My lord, the amount has already been sanctioned to the ADM, the respondent number 4.
Sanctioned?
Forwarded.
Okay, come on.
Forwarded.
Lordship, with this ground, we can't.
As per the prayer made by the council for the
Bankura Jila Parishad.
Respondent number 2, my lord.
Respondent number 2. Case is adjourned. Let the matter appear on 18th.
Kobe?
18th.
18th. I'm grateful. Lordship, the affidavit of service may be taken on record.
Service we kept with the record.
Grateful, my lords.
Yes, next.
Item number 30. May I please, Your Lordship? I am appear for the petitioner. Lordship, the son of the petitioner, Lordship, was found in an injured condition. He was admitted by the father in the hospital. The hospital authorities handed over the son to the CWC. Lordship, there have been earlier rounds of litigation before this court.
What is the age?
Lordship, at the time the son was admitted to the hospital was about 2 months. 2 months.
2 months?
At that time. It was a year back. The incident had taken place a year back. Now, there have been earlier rounds of litigation before this court. Lordship, the court on an earlier occasion had directed the CWC that let there be a DNA test because they were doubting my parentage. That DNA test has come. I am the parents. The court said that upon getting the DNA report, I'll be free to make an application to them for custody of the child. I have made that application. Lordship, they have not responded to my application. Lordship, the Juvenile Justice Act, on the basis of which the CWC functions, also requires them to conduct an inquiry. And the first preference is rehabilitation to the parents. None of that has been done. I have been informed by the respondent number 4, Lordship, that they have now decided to place the child for adoption without following any of the provisions of the JJ Act, without considering my representation. Your Lordship takes the first order, Lordship. The earlier matters which had been taken place before this court, page 73.
You are the mother?
I am the mother, Lordship.
Father?
Lordship, earlier they were not married, now they are married. The first representation was by the father. The father.
So this child is out of the marriage of?
Before the marriage.
Before the marriage.
Before the marriage by them,
Single
but
mother.
Single mother. Now they are married.
No, the mother.
That time single mother.
Child is a single marriage.
Single.
Okay. Subsequently she married. So she is the biological mother.
Biological mother. and the child was admitted to the hospital by the biological father. That is there in the documents.
Biological, who is the biological father? Now
To
who are married?
whom I am married, Lordship.
Who are married?
To whom I am
Is
married.
now
Biological father. Lordship, page 73, if your Lordship sees, this is the first.
What is the age of this lady?
This elite.
21 years.
Right now, 19 years, Lordship.
19 years.
19 years.
When the incident was occurred?
Lordship, the incident took place on.
When the child born?
23rd of March 2024, the child was born, and on 16th of April 2024, the child was admitted to the hospital.
What is the date of birth? What is the date of birth of the child?
23rd of March 2024.
23rd of March
2024.
2024. 2020. Yes. Where is the order? First order?
Lordship, may kindly come to page 73. Order dated 3rd of May 2020.
3rd June 24.
3rd of June 24.
Yes.
অ্যাডপশনটা এখানে বলেছে দিয়ে দিয়েছিল দেখো এই কাগজটা বার
This was the initial order. This writ petition got disposed of.
24 ওটা কি দেখো It's 77.
You have a legible copy of the order. What is the?
Lordship, it was illegible. I noted it.
Page 2, paragraph 3,
If there is not dispute with regard to the parentage of the minor child, then the Child Welfare Committee, in the presence of the police, shall hand over the minor child to
the petitioner.
To
Yes.
the petitioner. 674. Now, Lordship, this writ petition was disposed of. Order will, your Lordship will find at page 77. At that time, the state said that they have filed an FIR regarding to an injury to the child. Page 77.
এই বলেছে দিয়ে দিয়েছে বলেছে
Page 77.
Lordship, in the same writ petition, it was disposed of.
না না অ্যাডপশনে দিয়ে দিয়েছে এখানে ইনস্ট্রাকশনটা পড়ো
DNA test and return on the
may only indicate that the presence of the committee will be required. Because today, my lord, there is a further complication that I appear for the commission, my lord. My lord, there is a further complication that the child has already been, by the committee, the child has already been given in adoption.
Already?
The child has been over information we don't have. In fact, in my learned seniors appearing, the respondent that my learned seniors appearing for, respondent number 4, sir.
3.
Lordship, they are from them that we have also received that information. The juvenile.
Who made an application for return of the child?
Lordship, the application first representation
after the order of 3rd July.
It is noted in the order, Lordship. If your Lordship sees page 78, bottom. The paragraph 6, it is informed that the CWC is already been.
Paragraph 5, the law provides for the mechanism how the parents can approach the welfare for the return of the child. Will liberty to do so strictly in accordance with law and the appropriate stage the DNA result will be available. CWC already been approached. The CVC will decide the prayer. Where is the CVC? They have taken any decision?
No, Lordship, no decision. We have repeatedly written.
You have made a party to the CWC.
CWC is a party.
That's point number 2, my lord.
Yes. Copy served.
Lordship, copy the affidavit.
Their presence will be required.
Yeah,
Now,
their
this is a
presence is required.
little complicated matter, my lord. Today, what is parameteria, what is, my lord, of prime interest is the interest of the child, my lord.
That's correct, but we have to see the natural mother and father also.
Absolutely. But, my lord, again, the expert committee is of the
That's
opinion that the child was abandoned by the mother and, my lord, the child was found in rain. It is the allegations, my lord, the child's mother's mother, as the grandmother, has thrown the child to the streets, into the drains. My lord will consider everything.
That's the report has to come.
Absolutely. That is,
They have made a representation, the CWC how to be recorded that, and they take a decision, appropriate decision. They are
my lord,
not
the
the proper
commission
person.
commission has also, my lord, written to the CWC indicating that you should take steps and will file appropriate report. But possibly CWC was a little slow on it.
To decide the present it application, this court find that a report from CWC being the respondent number 2 is required. In spite of service of notice, none appears on behalf of the CWC, Child Welfare Committee, Kolkata. Accordingly, the petitioner is directed to serve the notice again to the Child Welfare Committee, Kolkata. By tomorrow, by Tuesday.
CWC Lordship. Lordship, I serve.
By 18th of November 2025, full stop. The CWC is directed that after receipt of the notice to submit a report before this court on 24th of November 2025. Let the matter appear on 24th November under the heading urgent motion.
We are grateful, my lord. We are grateful, my lord.
Lordship, be pleased to direct a stay of the adoption proceedings till then.
Unless the report is how can.
Thirty-one, I am for the petitioners. In this matter, I am praying for a leave to file a supplementary affidavit because certain documents are not incorporated in the writ petitions, and these documents are required for effective adjudication of the instant matter, and that's why I am paying for a leave. And what about the main matter? I am telling to your lordship, the petitioner is a supplier of the cashew nuts. He is
supplier of
cashew nuts. Now he is purchasing the raw cashew nuts from Nigeria, now processing here, and now selling this cashew nuts to the other country. Now the marketing committee, they are trying to impose the levy on the ground that you are transacting this cashew within my area. But that document, sales voice, purchasing voice are required to be annexed so that I can prove that this transaction has not been taken into account within your area.
So now what you want?
A supplementary affidavit, 2 weeks time can be given as supplementary.
As per the prayer made by the counsel for the petitioner, petitioner is granted. Petitioner is granted leave to file supplementary affidavit by 1 week.
Only 2 weeks kind.
Within 2 weeks, after serving the copy to the respondents, let the matter appear on 4th December.
এখানে কাগজ নেই কিন্তু
I beg to appear for the petitioner.
But I appear on behalf of the CSC in this matter, madam.
New connection petitioner purchased flat on 26th of March 2025.
2025.
2025. Well, applied for new connection on 8th of May 2025. 8th of May. Inspection was conducted by the CSC, my lord, on 10th of May. Thereafter, my lord, I find from the, my lord, the website, that track report, that an objection has been filed by the promoter with my connection on, my lord, 9th of June. Thereafter, I made complaint to the CSC authority for giving electricity connection. My lord, it is settled, my lord, when a purchaser of a new flat, my lord, he is entitled to have the electricity.
And only thing, my lord, I have just been handed over with the copy. May I take instruction, my lord, and come back? My lord, keep it on Monday as to be mentioned. I'll come back with him.
Counsel for the CSC.
My lord.
Service be kept on record, my lord.
Affidavit of service filed by the petitioner be kept with the record. List of counsel for the CESC, press for a day's accommodation to take instruction. According cases adjourned, let the matter appear on 18th.
18 Tuesday.
Tuesday.
As to be mentioned, madam.
As urgent motion.
I'm grateful. কত তারিখে? 18
Let the
তারিখে।
heading adjourned.
I'm obliged.
I appear on the state respondent.
My lord, I am for the petitioner.
But appearing for the private respondent number 3.
Well, this is a writ petition challenging an order passed by the competent authority under the West Bengal Apartment Ownership Act.
Yes.
Well, on the basis of a complaint of one flat member out of 250 flat members of a complex in Rajarhat, my lord, this order has been passed restraining construction of a temple and an ATM in the common areas on the basis that construction of a temple and ATM is contrary to section 5(5) of the Apartment Ownership Act, which says basically that percentage of ownership of common areas will not be changed without consent of parties. But competent authority has gone on the basis that any portion of the common area will not be changed. My lord, if your lordship takes the section first, my lord, 5(5) of the Apartment Ownership Act, my lord, I will just hand over one, my lord. My lord, it's marked, my lord.
No problem.
Just your lordship ignores the markings, my lord. Your lordship takes 5(2), section 5(2).
Yes. Yes.
Lord, I will just. Lord, 5(2), the percentage of the undivided interest of each apartment owner in the common areas and facilities as expressed in the declaration shall not be altered without written consent of all apartment owners. My lord, the operative word is the percentage. So that means whatever the the buildings, the common area may be, let's say, 100 square feet. That 100 square feet will not be changed.
Correct.
Now, my lord, the ATM and the common and the temple is being constructed in the common area. The character of the ATM or the temple does not change the common area to a private area in any manner whatsoever.
No.
The common area,
Percentage
it
of the
remains the
undivided
common area.
interest of each part of owner of
Yes, my
common
lord. The
area.
percentage will not be changed.
No, percentage of the
Yes, my lord.
undivided interest of each apartment owner in the common areas and facilities as a declaration shall not be on without the
Undivided interest.
Yes, my lord. So the percentage will not be changed.
Undivided
so, my lord,
interest.
let me complete my arguments, my lord. So, my lord, the temple is part of the common area. It's not partaking a character of a private area in any manner. Same with the ATM also. It's for the common purpose only. The entire complex, apart from this one flat owner, has consented to it by SGM also, my lord. No one has a problem in the temple and the ATM to be constructed. It is only this one flat owner who is saying you cannot do so. And now if your lordship takes the order which has been passed, if your lordship takes page 30, it's a one-page order only without reasons, but that apart, if your lordship takes the order. My lord, page 30, the last portion, last paragraph. And whereas, upon careful consideration and submissions made by both the parties, and in light of section 5 of the West Bengal Apartment Ownership Act 72, it is observed, common areas and facilities are collectively owned by all flat owners in proportion to their undivided interest. No problem with that. But next line, no portion of such area can be altered without prior written consent of all apartment owners as required under 5(2) of the Act. So, my lord, here is where, my lord, the competent authority has gone wrong. No portion.
And the facilities are collectively owned by apartment owners.
No problem with that. The next, no portion of such common area can be altered. The language of the section is no percentage of the common area will be altered. as required under 5(2) of the Act. The construction of the mandir in the common area and levying charges upon apartment owners towards construction is not in conformity with the provisions of the Act of West Bengal so and so. The installation of the ATM in also amounts to change of use of common facilities. Well, the allegation of change of use of common facilities is not what is contemplated under 5(2). Malad, the mandir as also the ATM will be common area only. It's not like it's a partaking character of a private area or as being sold. So portion and percentage are altogether different. 5(2) contemplates percentage. Malad, the flat owner might have 0.1%. He's a 300, there are around 240 flat owners. So Malad, he will have say 0.5% share in the common area. That remains, that does not change. The flat, alleging that when construction, and this is only one flat owner who has complained of this. This is, and now if your lordship sees the order, and whereas in same page 31, and whereas in view of the above observations and in exercise of the powers conferred under 16B1 of the Apartment Ownership Act, the President ECOS is hereby directed to desist from permitting the construction of any mandir or any permanent structure in common areas without unanimous consent and statutory compliance. One flat owner out of 240. Stop levying any charges upon the apartment owners towards such construction unless approved by the Act. Refrain from permitting installation of the ATM counter or any commercial facility in the common area without consent of all apartment owners and sanction thereof. Strictly adhered to. Now, my lord, why was this complaint made? That's also, there's a, this is completely vindictive attitude by one flat owner. Why? My lord, if your lordship takes, my lord, there is a board meeting which had happened of this Apartment Ownership Act, Apartment Association on 23rd February 2025. If your lordship takes page 62. Sorry, my lord, not 62, 62. My lord, I've written a wrong page number. My lord, page, it should be page 59. 62, my lord, 62. My lord, page 61. What has happened, my lord? This particular flat owner, he was making internal construction and internal alteration in his flat. So a notice was given to him. And this, if your lordship takes page 61, if your lordship sees, this is a meeting of 23rd February 2025.
Yes.
If your lordship turns over, and my lord takes serial number 6. Action taken by association in connection with alteration of the interior areas without approval. It was discussed regarding alteration of interior works of flat number 106. Well, 106 is the particular flat owner and 206, both in Tower 4, and necessary communications from FM office to rebuild the structure. It was decided to issue notice to the concerned flat owners with a direction to rebuild the structure of kitchen and implement necessary action as deemed fit as per bylaws if the owners fail to comply with the direction of the association which were accepted by the house. So a notice was issued to him on the basis of this meeting of 23rd February 2025.
Yes.
Immediately after that, my lord, if your lordship now takes page 34. April 2nd, 2025, he issues this complaint.
Yes.
2nd April 2025, he makes this complaint. And my lord, most importantly, prior to all this happening, in December 2024, there was a SGM of all the flat owners, my lord.
Yes.
Your lordship will take page 54. Page 54, your lordship will see this was a SGM of all members on 8th of December 2024. He was present in this meeting also. If your lordship turns over to page 59, serial number 11. set up temple at ECOS premises subject to approval of SGM. It was proposed to set up, well, page 59. I think it is 50. 60, well, 60. 60.
Yes.
Page 60, serial number 11.
Yes.
Set up temple at ECOS premises subject to approval of SGM. It was proposed to set up a temple at ECOS, and for that a suitable place will be fixed as per sanction plan after handover of property, which was accepted by the house.
Yes.
He had accepted this in December.
He was present.
He was present, my lord.
Where it is.
My lord, all the members were there, my lord, in the SGM, my lord. My lord, I don't have a separate list of the persons who are there. So, my lord, if your lordship sees the chronology of events, December 2024, at the SGM, decision to construct the temple happens. He agrees to it. No problem. In February, my lord, a notice is sent to him saying that you are making illegal construction. That's when he makes a complaint.
Yes.
And complaint is with regard to construction of the temple and the ATM.
Yes.
And my lord, he's got this order after that. And most importantly, this is not, my lord, what is contemplated under the Act. Section 5.2 as also 5.5. Both, my lord, permit such thing, my lord. If your lordship takes 5.2 and 5.5.
Replacement of construction of temple.
5.2, if I read again, the percentage of the undivided interest, it is not the portion of the undivided interest of each apartment owner in common areas, facilities as expressed in the declaration shall not be altered without written consent of all apartment owners. That is not being done at all. The percentage remains the same. The total area of common area remains the same. All that is happening is a temple is being constructed in the common area. It does not take away the total share of common area at all. It doesn't change the percentage of common area at all. And this is nothing but a vindictive litigation. It has been filed only for because the association had taken notice of the fact that he's making illegal construction inside his apartment.
Okay.
So I'm challenging this order and the order is also, my lord, without any reasons. And it goes on the completely wrong premises of portion and not percentage.
Okay. Yes, sir. Who is for your
No, my lord, I appear on behalf of the state respondents.
Who is for the private
But I am for the private respondent. My lord has seen the order, which is at page 30 as placed by my learned friend. Now, my lord, this order, my lord, was passed on the basis of the complaint lodged by the petitioner.
Yes.
Now, my lord, prior to that, as has been placed by learned friend, that I have made certain illegal constructions or whatever has been alleged, and since they have issued some notice to me, I have raised this objection. But this is a wrong statement. I have documents. I have other meeting resolutions where I'll satisfy your lordship that I had been raising this objection against these. Well, there are three issues. One is construction of a temple, the ATM, and they are levying certain charges when somebody wants to sell out the property. If I am the owner of a flat, then if I want to sell it out to some other third party, I'll have to pay a certain amount to the association. That was also one of my allegations that has not been taken care of by the complaint authority. I placed my complaint. It's there. Now, prior to what has been placed by my learned friend, that I was there. First of all, I have taken instruction on that, but because I have instructions as of now that I was not present in any of those meetings where this kind of resolutions has been adopted. Now, with particular to this, as has been placed by my learned friend at page 60, but I should take instruction whether I was there or not. My learned friend could not produce any document showing that I was present there. Now, prior to December 2024, I had been raising objections with regard to installation of the ATM and the temple. Now, I have the resolution where it says that the complaints lodged by my client were not at all discussed, and in a single line they say that this need not to be discussed. This is how my complaints were being brushed aside. Lordship kindly takes up the complaint before the complaint authority, on the basis of which the order was passed. This is at page 34.
Yes.
Under instructions and on behalf of my client, I submit as follows: that my client is the resident member of ECOS Association Apartment Owners and having address as mentioned. Then, my lord, those things. Then, my lord, that this is a complaint against the board members of Eco's Association of Apartment Owners, Registration number so-and-so, whose actions are sought to be struck down and quashed for the following reasons. Lordship kindly says ratification for introduction of one administrative charges to be payable for selling flats as per description hearing. But this is their charging that if it is a 2 BHK flat, I have to pay 30,000, 3 BHK flat, then it becomes a 40,000 and 50,000 for 4 BHK.
Well, that part is not subject matter of challenge at all.
But I have not interfered. The aforesaid ratification was introduced as per minutes of adjourned special general meeting dated 21st July 2024. My clients were aware that the said meeting was attended by a handful of association members. Well, what they are doing is they are calling this meeting from time to time and inviting some of their own some of their persons who are at part with them and taking out these resolutions. And today my learned friend could not produce a single document for Lordship.
What is actual?
But I'll tell you, Lordship.
What is the dispute? Why you are raising such objections?
But this kind of things cannot be done.
Leave aside that. Leave aside. I will take the with regard to the temple and what is your objection on that?
But this they cannot do without my consent.
That's why this is the authority. What is your objection for not allowing to construct the temple and the ATM? ATM is for the public purpose.
No, then my lord, I have to take instructions. I sit with my solicitor and also the client. Then my lord, I come
take
back.
Instruction with regard to the whatever the allegation that the court will take care of
it. But the first charge is very serious.
Correct. That's what I'm telling. Whatever the allegation that will take care of it.
Yes.
With regard to this construction of the temple and the ATM, that is for the public purpose, and please see to that.
Very good. I'll talk to my client. I'll come back.
And with what are the allegation, I will take. Let them take the decision. Let the
very good. I'll come
meeting and decide that they are not doing that. Then
but Lordship will also might consider their fast this imposition of these charges.
What are the allegations?
Embezzlement.
Before this court, with regard to the order passed by the authority on the basis of your complaint.
Right.
Now you have raised a certain complaint allegation against. That will take care of by this court. But see,
very good. Since your lord, if this has fallen from your lordship, I'll take care of it. Lordship grants me 2 weeks time, I'll come.
No, the construction of the ATM.
No. How can that be done right now? Let us come back. No, let us come back.
Not give 2 weeks. Give 1 week.
No, I need some time. I need some time.
Well, instruction as to the that should not be 2 weeks.
Simply.
Well, this is a common area.
Okay, 10 days. The counsel for the private respondent seeks time to take instruction. Accordingly, case is adjourned. Let the matter appear on 25th November.
Well, the order of the competent authority is only restricted to the ATM and the.
That's why I told you with regard to the order of the court and with what the allegation. Let me take your. Yes. Next.
Lord, appearing for all the respondents.
It's my application. It's Lord, coming from a denial of an application under RTI Right to Information Act. But my simpliciter.
Denial by whom?
By the first level authority, Lord.
By both. Second appeal prepared.
I have not preferred any second appeal yet.
Why?
Kindly see the way it has been denied, and I'll show the exception under what circumstances. Even if there is an alternative remedy, I can come to it. Petition that it is settled. But so far as the denial is concerned, the denial on the ground is that if the information is provided to me, that would involve third-party information, personal information of third party. The Act provides a particular section that if the information sought reveals any information of a third party, then there is a mechanism provided under the Act itself. No attempt was made by any of the authorities to take any that measure under Section 11. Now, I'll show that. First, I'll place before your lordship the information that I sought. How can that involve any third party's information? But kindly see page 14. That's my application, Milord.
Page 14.
Page 14 of my writ petition, Milord.
Yes.
This is the other three information I asked. Copy of all documents, undertakings, affidavits submitted to BPCL in which my name, the petitioner's name, appears or is referred to or is in any manner connected, whether during the application stage, draw process or thereafter. Copies of all correspondences, emails and submissions made during or after the draw process in which my name is mentioned, referred to, otherwise involved. copies of all submissions, affidavits, undertakings, or any documents made by me or involving my name if such record exists with BPCL. So I am seeking information about myself. If my name has been used in any of the tenders or contracts granted by BPCL, that's the purpose of this information. Now, next page, the response. I'll show the response and then I'll show why the second appeal would lead to the same thing. Kindly the response, first response, page 15. I'll not repeated. The first part is the queries. Our reply is as under. We are of the opinion that the information requested as above pertains to personal details, the disclosure of which bears no relevance to any public authority, activity, or interest. Sharing such personal information would constitute an unwarranted invasion of individuals' privacy. Accordingly, the request is denied. 81J. Whose information? My own information. They say that if they give information about myself to me, that would not, according to them, that would violate that would violate the unwanted individual's privacy.
No, submitted by the Swati Mishra to BPCL. Submitted by, kindly come to the question number 1.
Yes, Pilot.
The copies of all documents, undertaking, and affidavit submitted by Swati Mishra
That's
to
right.
BPCL. In which your name?
No, Pilot. Kindly see, they are misquoting it. My question, that's why I shown. First page, page 14. What were my queries? 1, 2, 3.
Copies of the all document affidavit submitted to BPCL by whom?
I did not mention anything. I said if my name is found in any of your records,
how it can be?
They are construing, and we
How it is possible? You're telling that please provide the document in which documents my name is appearing. How the authority, unless you
but that's not the ground they're taking. They're not saying it is impossible to find.
But they have
They are
taken that.
saying, yes, Milord. So they are saying that, which means these Swati Mishra's documents, affidavits, and undertakings contain my name. This straight away comes to this. So I now, Milord, from this, it is evident that my name has been used in any of the this Swati Mishra's affidavit, undertaking, or document that is clear from this document. Now that I filed the first appeal. Next page, page 16.
Yes.
Instruction. This is the appeal.
Yes.
Milord, the response of that is at page 18. I'm not reading the appeal, it's same thing. We have perused your appeal with respect to your RTI query dated and such, and note that reply was provided by CPI West Bengal, not West Bengal and such. However, the specific information requested, such as copies of all documents, undertaking affidavits submitted by the selected candidate against draw rate and such, for the location dated Howrah, constitutes either party personal in nature or information sought, including commercial confidence, trade secrets, and disclosure of which have no relationship to any public activity or interest, and would be an unwarranted invasion of privacy of this individual, or would harm the competitive position of a third party, and hence 81J and D of the RTI Act respectively. Now, Milord, from these papers, I don't have any other documents to show. These papers, Lordship, is one thing is clear, that my name has definitely been used by at least some Swati Mishra. Now, Swati Mishra has used my name, and because of that usage, I now can't apply for any participation in that authority, because my name has been used once without my knowledge. Now they are referring to 81J. I'm just handing over the RTI Act. I'll show me that the violation of the statute, then it would be, then I'll be. Eight 81J they are referring to, Milord.
Yes.
Give me 1 minute.
Yes.
Just give me 1 minute, please. Network issues. Okay. 8.0. I'm reading it. Notwithstanding anything contained in this act, there shall be no obligation to give any citizen.
No, J.
J.
Information which relates to
personal information, the disclosure of which has no relationship to any public authority, activity, or interest, or which would cause unwarranted invasion of privacy of the individual, unless the central public or the state public and such as the case may be satisfied that the larger public interest justifies the disclosure of such information. This is the bar that they are saying. It's not actually a bar, it's an exemption. Authority is exempted from disclosing these information. Now, Amlar, kindly come to section 11.
Section
11.
Yes.
This section particularly deals with this situation, Miller, where a central public information officer or state, as the case may be, intends to disclose any information or record or part thereof on a request made under this act, which relates to or has been supplied by a third party and has been treated as a confidential by that third party, the central public information officer or state, as the case may be, shall within 5 days from the receipt of the request give a written notice to such third party of the request and of the fact that central officer or state officer, as the case may be, intends to disclose the information or record or part thereof, and invite the third party to make a submission in writing or orally regarding whether the information should be disclosed, and such submission of third party shall be kept in view with taking a decision about disclosure of information, provided that except in the case of trade or commercial secrets protected by law, disclosure may be allowed if the public interest is disclosure outweigh the importance, any possible harm or injury to the interest of such third party. So the procedure is mentioned. If I apply, they feel it's privacy breach, they will in 5 days they shall ask the third party to give in writing.
Yes.
And depending on this procedure has not been followed, outright denied. That's first. Second, my lord, it has been categorically held by the Honorable Supreme Court that if that information which I am seeking relates to myself, then this exemption
will not come in.
Will not comply. I can come back on the next day, because
Yes.
this is my
Lordship, this can be disposed of. Provision of 19(3) is their appeal, assuming the orders are wrongly passed and does not stand as scrutiny by a higher forum. So the appellate forum, it's a self-contained act.
She will clarify the law.
Provides for alternative remedy. He says in the writ petition there is no other alternative.
No, I am saying.
So for
it's a
every
breach of
case,
statute. It's a breach of statute. Alternativity is no bar. I am carrying that
I
judgment as
didn't
well.
utter a word when he spoke. Now Lordship
But I have
asked me
not-
to submit and he will interrupt my.
Sorry, I
He shouldn't
apologize.
do it.
I apologize.
Yes.
My lord, now the person who says some Swati Misra is actually his wife.
Yes.
He wants documents of his wife, which are private in nature, used for the purpose of.
Whether you complied with the 11, have you issued the notice to
If I
submit?
intend to give, then only I'll ask for that.
What intent to?
Kindly see in the 11.
Yes.
In case I intend, if he intends to disclose the information, then
Correct.
only he will issue a notice.
And he is not asking with regard to Swati Misra document. He is asking the document which
Swati
submitted.
Misra documents would
It is not a personal document he is
That
asking.
cannot be segregated. This is an application for grant of distributorship where so many documents are filed.
Correct.
That's a bunch of documents. Could be bank documents, could be guarantees, could be land ownership, everything. Now, those do not constitute.
Okay, come tomorrow.
We're on Monday.
The counsel for the petitioner has argued the matter. Counsel for the respondent has argued the matter as done, but due to paucity of time, hearing could not be completed. Let the matter appear. 17.
But the video service will be kept on record.
My lord, 18th, my lord, if it prefers your lordship.
17, 18.
18th, lordship.
Let the matter, 18. Instead of 17, 18, huh?
18.
Yes.
The original,
Great similar.
the original side matter, your lordship asked me to come again.
Under the heading, urgent motion.
বইটা ফেরত দিন।
Adjourn motion, sorry, adjourn motion.
না আজকে এর বইটা ফেরত দিন।
Yeah, just a minute. Let the officer.
May I get back the book? এখন অডিয়েন্সের আছে নাকি? ও রেসিডুয়ারি অডিয়েন্স একটু তাই।
अरे यहाँ फाइल तक कहाँ देख यहाँ एक फाइल रखा था बोलिए नहीं yes
Item number 10 and 11, your lordship had fixed it at 2 p.m. today. So it could not be taken up. And your lordship said any day can be fixed.
yes when
But
21
Not on a Friday.
not on Friday.
Not a Friday. Well, 3:30 will again face the same.
But
problem.
only thing we have filed an application, it is supposed to come upon 21st.
Let it appear along with this whenever your lordship.
Item number 10 and 11.
Yes, together your lordship was hearing it.
As per the prayer made by the counsel for the parties.
And as far as I recall, on the last occasion, my learned friends, we were about to start in reply. My learned friend said that he still has some points to cover.
Yes, yes. And hardly 10.
Otherwise, we will make our submission.
Let the matter appear on 25.
25. Will it be marked, my lord?
अच्छा 25 witness है 25 26 27 है ना 24 में है arbitration again 1st December
No time change আছে
Topic, let it be at the top.
at the top.
Oh, my lord, my advocate on record will not be there. Is waiting, my lord.
Convenience.
Thinking after that, can we get any day before it's possible?
21st November.
Before, because 25 26 27 and there is a special matter. Witness is coming out.
And 21st, your lordship will keep it. My lord.
Take chance.
Yes, let it be. Let
21st.
21st as the
Take chance, if not.
Yes, yes. Your lordship can consider, in case my lord 3:30 takes place, original side then can be taken at 3 p.m. That your lordship will consider.
Let me see if it in the you check the cost list.
Yes.
Great.
Kindly, item number 8. Similar rule was made returnable today. Now, according to the rules, the contemner has it has been served. The rule has been served by the sheriff office. Now, according to the rules, he has to be present today, irrespective of this 3:30 or 4:30. I don't find anybody. Item number 8.
Item number कितना है?
10. Because he is not appearing anywhere. That matter defamation. That Aditya Vikram Billa defamation. That LinkedIn. So in that view of the matter, I will be seeking issuance of
warrant of arrest.
I'm led by Mr. Ray Miller. So rule has been served. I've checked well in advance.
Attempted to serve upon.
No. Affidavit has been filed. Rule has been served. That is my lord's officer. That would not with us. That affidavit filed by the sheriff's office.
The sheriff office is doing so much more. Written answered. How many? One contemner, na?
It was also served through his WhatsApp number also.
Parvez Sukla.
Yes, it was also served with his registered WhatsApp number also.
Might be, but as per the report, I send him a scanned copy of the rule of contempt, WhatsApp message, and as for the original copy of this contempt rule, along with the duplicate copy, same are written as answered.
Yes, but here
it's sort of the electronic communication through the WhatsApp messenger is.
I am also told he has replied by the WhatsApp message by saying thank you. Kindly see the screenshot of the WhatsApp message. If kindly see Milo's order. That has been sent by scan copy. Then he has replied thank you. Kindly see the last chat. So he has replied thank you. So he has to come. Only saying thank you will not help. I am obliged hearing thank you. But arrest warrant.
Given the thanks to you.
Yes, but I am obliged. But I will more of.
Malad, he has accepted the invitation, Malad, with a thank you.
Yes, he has
But he is
accepted
not
the
here,
invitation.
But it's his choice whether he has come for the
No,
invitation
No,
or
no,
not.
this is not
Now,
a
this is
choice,
not a
Malad.
choice. This is not a choice.
By an order dated 31st of October 2025, this court has issued rule upon the alleged contempt. In terms of the order passed by this court, the petitioner has taken appropriate step for issuing the rule upon the alleged contempt. The office of the sheriff has submitted the report along with the affidavit, wherein it reveals that the scanned copy of the rule of contempt sent through WhatsApp Messenger, and the original copy of the rule of the contempt, along with the one duplicate copy were also sent, but the same was written unserved. The WhatsApp copy has been received through the WhatsApp message by the alleged contemptor, and on receipt of the said rule through WhatsApp, the alleged contemptor has given the report in thank you. In spite of the receipt of the rule through WhatsApp, the petitioner has not appeared before this court in person. Accordingly, this court has no other alternative but to issue warrant against the alleged contemptor. The petitioner is directed to take appropriate steps for file requisite in the department for issuance of the warrant upon the alleged contemptor. The office is directed to take appropriate steps for execution of the warrant upon the alleged contemptor. Let the matter appear on 26th November 20.
Grateful.
Yes,
next. Milad, I have spoken to Milad officer, Milad, the Rahi matter, Milad, I'll finish Milad on 17th. Milad, Mr. Drolia, Milad, I am ready, Milad, I'll take the day, Milad, I'll finish. You can kindly keep it, Milad, at the top so that I can finish it off. I'll not take much time, it's already done. So, Milad,
you 1 week, then I will.
No, it's there, Milad, giving a chance to Mr. Drolia, he will next year. So, Milad, I'll finish it on that day, that I assure your lordship. If Milad kindly takes it up on that day, any point, Milad,
when?
17th Monday. It's fixed on Monday and 19th.
So come on 19th.
Yes. No, 17th and 19th. Both they were fixed. So Milad kindly, fixed. Time fixed. But Milad now Milad.
The time? 2 p.m. 3:30 come.
Very well, Milad. I'll take chance. Kindly keeps it at the top so that I can finish it off. I'll finish it off.
Okay. Next. Any?
Item number 3, my lord. The judgment, my lord.
Where is the matter? Item number 3 क्या है? So, fine है? Yes. How many legal layers?
My lord, para 5, my lord.
Huh?
Para 5, my lord, 4 legal heirs.
Para
One
5.
is, yes, my lord, 1 executor. Everybody has consented.
Have you given consent? Consent filed?
Yes, my lord, it is in my lord's record.
Where is the consent?
It is, my lord, affirmed on
3 है. सुलोचना अग्रवाल
12th May 2020. Sulochana Agarwal, Rajarshi Goyal, and my lord Joyce Goyal. Joyce Gupta.
And who is the witness?
Yes, my lord. Witness is also there.
Where is the will?
Yes, my lord. Will. Page, my lord. Page 11.
Especially assign है ना? Witness का है? Witness का है? One witness has given?
Yes, yes, my
lord. Gautam?
Yes.
Well, what is the date of death?
Date of death is, my lord. 22nd of May 2021.
22nd May 2021. What about the wife?
My lord, wife died, my lord.
Widow Sulochana?
Yes, yes, yes. Sulochana is the widow.
She is the wife.
Sulochana is the widow.
The petitioner has filed the present application for grant of probate of the last will and testament dated 31st of August 2020 of the testator of the testator Purushottam, P-U-R-U-S-H-O-T-T, Purushottam Lal Agrawal, A-G-A-R-W-L, Agrawal. Police. Petitioner says that the testator died on 22nd of May 2021, leaving behind 5 legal heirs, that is wife.
4, my lord.
Four legal heirs, that is wife, son, and 2 daughters. The son Manish Agrawal is the petitioner before this court, who is the executor of the will of the testator. The wife and the 2 daughters have also submitted their affidavit of consent, stating that they have no objection for grant of probate of the last will and testament of the will dated 31st of August 2020 to the petitioner. 31st of August 2020 to the petitioner. The petitioner has also filed an affidavit of attesting witness. The attesting witness, one of the attesting witness, namely Gautam Chakravarti, has also filed an affidavit stating that the testator has executed his last will and testament in his presence and in presence of another attesting witness, namely Kedarnath Agrawal. On 31st of August 2020, while possessing good health and fit state of mind, by appointing the petitioner as sole executor of his last will. Counsel for the petition submitted, as all the legal heirs have filed their affidavit giving consent for grant of probate, and there is no other objection from any corner. He further submitted the attesting witness has categorically stated in the affidavit that the testator has executed his last will and testament in his presence and in presence of another attesting witness while possessing good health and state of mind, by appointing the petitioner as sole executor of the will. He submitted the petitioner has proved the will and is entitled to get the probate. Had the learned counsel for the petitioner perused the original will, death certificate of the testator, affidavit of consent of the wife and 2 daughters, and the affidavit of the attesting witness Gautam Chakravarti. This court finds that the petitioner has proved the will and there is no circumstances to raise any suspicion for execution of the will by the executor, by appointing the petitioner, by the testator, by appointing the petitioner as testator of his last will and testament. Accordingly, the petitioner has proved the will and entitled to get the probate. The department is directed to issue probate to the petitioner of the last will and testament dated 31st of August 2020 on compliance of all formalities. At the time of grant of probate, the copy of the will be made part of the probate.
The order need not to be
disposed of.
The order need not to be drawn up.
It is not necessary to draw up the order. पार्टी है तो देगा पार्टीज है
Yes, my lord.
My lord, I appear for the petition. Parties, my
petitioner.
I appear for the opposite parties, my lord.
APCOM 272 of 2024 is dismissed.
Grateful.
Yes.
Obliged.
Great. This court find that as per the settlement agreement, the defendant has agreed to pay rupees 31,28,000 to the plaintiff, but the defendant has not paid only rupees 10 lakhs. Thus, the defendant is directed to pay the remaining balance amount of rupees 21 lakh at 28,000 to the plaintiff within 4 weeks, and the remaining claim of the plaintiff along with the interest is relegated to the trial.
Yes.